Thank you, Chair. Chair, we'd taken the lunch adjournment in the expectation that we would be returning for Professor Mokgoro to be re-examined. But before the lunch break, I'd requested an opportunity to consider some of the documents which my learned friend had indicated they had received recently and which may be pertinent to the matters involving Professor Mokgoro. I did take an opportunity to look through some of the documents over the lunch break. I understand there to be two separate sets of documents. There's a bundle that Professor Mokgoro asked his office to put together for him. That was the bundle that I'd seen some documents in. And then there's another set of documents which have also been obtained. The documents that I did see and discuss with the investigators are documents that certainly require further investigation. They are documents which the Commission has specifically requested over the period of this investigation, and we were led to understand did not exist. What I've seen suggests that those documents have been found and do exist. And in my submission, it would not be appropriate to proceed to the re-examination in a situation where there might be material documents that we haven't yet had an opportunity to consider and place within the full matrix of the evidence related to Professor Mokgoro's testimony. I have discussed the matter with my learned friend. I understand him to be essentially in agreement that what we propose be done is that we adjourn now insofar as Professor Mokgoro's evidence is concerned. He be released so that we can obtain the documents. I understand they'll be sent through to us by Professor Mokgoro's attorney in due course. They only have one copy here today. We can then consider them and then certainly engage with our learned friends about what we make of the documents and what the further process should be. I can hand over to my learned friend if there's anything he wants to add, if I may.
Yes.
Thank you, Chairperson. Just to indicate that we are in agreement with the process proposed.
Yes.
Also because we haven't also had an opportunity to have a view of the documents.
Yes,
So
okay.
it is only fair that we all get an opportunity to reflect on them.
Yes,
Thank
okay. Okay, no, that's fine. I don't have a problem that we do that. Therefore, we will postpone the re-examination of Professor Mokgoro to a date still to be fixed, particularly because his re-examination won't take long, and even if Ms. Hofmeyer, after having studied the documents, might wish to put some questions to Professor Mokgoro before re-examination happens, I don't think that that evidence would take long. I think we must all be ready that we might have to, Professor Mokgoro might have to come back for an evening session. We do hold evening sessions sometimes. So during the day, there'll be witnesses who give evidence, and other witnesses might come at 4 o'clock or 5 o'clock. We hear that evidence, depending how long it's going to be, might be up to 7, might be up to 8, and so on. So we might have to do that because a number of, most of the days are kind of filled up for the rest of the year. So we might have to do that. But if an opening happens, say, on one of the days, then we can look at that as well. So therefore, Professor Mokgoro, we are going to adjourn, postpone the hearing of your re-examination, and another date will be arranged and time, and your lawyers will let you know. Is that all right?
That's okay. Thank you very much, Chair.
Okay, all right. You are therefore excused for today.
Thank you, Chair.
Thank you.
Thank you very much, Chair.
Thank you. Thank you.
Chair, we next have the evidence of Ms. Memela. We do need to move things around a bit to ensure she has the right files.
Yes.
Could we take a brief adjournment to facilitate that?
Yeah, okay.
Thank you so much.
We'll adjourn.
Mfeka, umpotla uthiwa amanzi. Uzorhala apha yena.
Are we ready?
Yes, thank you, Chair.
Okay.
Chair, I'd like to just begin with orientating ourselves in relation to Ms. Memela's evidence, because the Commission last received evidence from Ms. Memela in February of this year. And in the course of that evidence, you had granted her leave to be re-examined, and that was confined to a period of 2 hours. There was an opportunity afforded to Ms. Memela to make application for a longer period if required, and she declined that opportunity. Now, since those events in February, the Commission has received the evidence of Mr. Nzeku. And Mr. Nzeku's evidence took place last month on the 26th of August. And that evidence implicated Ms. Memela in various matters, which I'll come to in a moment. It also implicated her legal representative, who appears today to represent her, Ms. Mbanjwa, who was also her legal representative on the last occasion that Ms. Memela appeared. So after Mr. Nzeku's evidence, the legal team and investigators through the Secretariat wrote both to Ms. Memela and Ms. Mbanjwa and indicated to them that Mr. Nzeku's evidence had implicated them and invited them to provide affidavits to the Commission in order to respond to Mr. Nzeku's evidence. There were responses received both from Ms. Mbanjwa and Ms. Memela. Ms. Mbanjwa's response came in on the 9th of September, and her attitude was that Mr. Nzeku had not implicated her in his evidence. She had concluded that the request for an affidavit from her was based either on a misunderstanding of Mr. Nzeku's testimony or on other ulterior motives, and so she declined to furnish an affidavit to the Commission. Ms. Memela's response was initially to ask for a series of the documents that had been referred to in the course of Mr. Nzeku's evidence, and those documents were provided to her on the 14th of September. They comprised the following. There were the 2 affidavits from the members of the police force at Mount Freer. They were the handwriting expert's affidavit and report. There was the affidavit of Chief Sikau, and there was Mr. Nzeku's affidavit and Mr. Ayer's affidavit. There was also a request for an affidavit from Mr. Phiri. Now, I must just remind everyone who Mr. Phiri was. Mr. Phiri was the acting CEO at the time that both the GPU sale occurred and the award of the tender to AAR and JM Aviation. There was a reference in February during Ms. Memela's evidence, and I think subsequent to that, for a version from Mr. Phiri to be obtained on matters. And Ms. Memela was told through attorney Ms. Mbanjwa at the time that the Commission had engaged with Mr. Phiri and that it was in the process of obtaining an affidavit from him. So when those first set of documents were provided to Ms. Memela on the 14th, the response to the request for Mr. Phiri's affidavit was responded to on the basis that as soon as the Commission received it, it would provide it to Ms. Memela, and that took place on the 17th of September 2010. There was a link provided. There might have been a little bit of a delay in her being able to access the link, but my understanding is that that's also been received by Ms. Memela. There was no affidavit forthcoming from Ms. Memela, despite the invitation for her to address the matters raised in Mr. Nzeku's evidence. And as a consequence of that, on the 23rd of September, we wrote again to Ms. Mbanjwa and notified her that because there had been no affidavit forthcoming and because of the evidence of Mr. Nzeku and its implications for Ms. Memela, the legal team would make a request today to be given an opportunity to question Ms. Memela about those aspects before the commencement of a re-examination. And she was advised that she should come prepared to be able to answer those questions. There was correspondence then received yesterday from Ms. Mbanjwa on behalf of Ms. Memela to say that they intended to object to that request. So what I'd like to do with your leave, Chair, is just explain why we make the request and motivate for it, and then if the objection is still persisted with, then to hand over to my learned friend, Ms. Mbanjwa, to make any submission she wishes to make. Thank you, Chair. Chair, we request an opportunity to question Ms. Memela in relation to Mr. Nzeku's evidence, because what he covered in his evidence is pertinent to the issues that Ms. Memela testified about previously. And I'd like to just identify the nub of the issue. Ms. Memela's evidence previously in February before this commission was that the payment of 2.5 million rand that came from JM Aviation and that was used to purchase her Bedford View property was not untoward in any way. It was not a corrupt payment. And the reason for that is because it was actually money that was owed to her mother, pursuant to a sale agreement that Mr. Nzeku had entered into with her mother, and which her mother had then simply decided to donate to Ms. Memela for the purposes of her property acquisition. That was the case in explaining, on the part of Ms. Memela, the receipt of the 2.5 million. The evidence that has been received from Mr. Nzeku is evidence in which he conceded in the end that that sale agreement was a fraud, that it was not entered into in 2015, that it was entered into or signed, at least by him, in 2019. And if that is so, Ms. Memela's entire explanation for the receipt of that 2.5 million is called into question. I submit there can be no doubt that that implicates Ms. Memela in very serious matters, and it is important for this commission to be able to question her, if for no other reason than to give Ms. Memela an opportunity to explain her side of the story in relation to the concession made by Mr. Nzeku. Chair, it's the work of the Commission to investigate matters. This is not an adversarial proceeding. It's a proceeding that often has fluidity in it. Witnesses get called back often. As matters develop, they get questioned by more than one representative of the legal team because they are implicated or have relevant evidence to give in different areas. And so it's in accordance with its investigative function, coupled with, I submit, the importance of fairness to witnesses against who implications are made to be afforded an opportunity to give their account of events. And so it's against that backdrop that we submit it would be appropriate to question Ms. Memela on the matters arising from Mr. Nzeku's evidence. I submit that she was given forewarning of the fact that the request would be made today. She's been provided with all the documents that she requested, and so there could be no prejudice to her with the matter proceeding on that basis today. And those are the grounds on which we submit it would be appropriate for the request to question her to be granted. If I may then hand over to my learned friend if there's an issue to be taken with that request.
Yes. Ms. Mbandra, do you oppose the request?
I do, Chair.
Stand closer to your mic.
Chair, I do not know when I'm sitting, maybe just for procedural reasons. When I'm sitting here, I'm raising my hand to raise an objection. I think I'm not.
Don't raise your hand.
Okay.
You'll be given a chance to speak at some stage. Don't raise the hand.
Oh, I thought I was invisible to the chair. So basically, the first thing which I want to do is just housekeeping. I just want to exchange.
I'm sorry, where you are standing, it may be that what you are saying is not captured by the recording properly, because I think you're standing far away from the mic.
It's the nature of the chair.
You can, if there is difficulty, are you able to speak close to the mic while standing?
I'm not sure, Chair.
Well, I'll allow you to sit down. I'll allow you to sit down and address me seated if that's going to make things easier.
Thank you, Chair. But first, can I walk over to Ms. Memela? I just want to exchange the bundle. I wanted the bundle. She took the bundle I was preparing on.
Oh,
she
took your bundle. Okay.
Yes, and then my pen is also.
Okay.
Chair, you will guide me if I'm not being audible.
Yeah.
Yes. Firstly, this request by...
So is the first thing that the objection stands, continues?
Yes. Yes, we are objecting.
Oh, okay, all right. Yes, give me your submissions, reasons.
First, Chair, we did write a letter to the Commission, and we said in the letter to the Commission, we are prepared to meet the Commission halfway. If the Commission has certain witnesses, that is Ms. Hofmeyer, which she wants to address to us, we will answer those questions. She can give them to us in writing, and then we will also answer them in writing.
Why must that be the case?
No, the reason why that must happen is because we are of the honest view that it is going to help us if we go first. And the reason why we are saying we should go first is because our understanding, I understand what Ms. Hofmeyer says about the fluidity of these
So
proceedings.
is the position that your objection is not to the request as such, but is to the sequence as to what should happen first?
Yes, mainly it is multi-pronged, Chair. Our starting with a first one, because remember, one must start being conciliatory in proceedings like this because we have a duty to cooperate. So we said, we want to go first. And the reason why we want to go first is because we are of the view that...
Okay, no, I just want to make sure I follow. Are you saying you have no objection to me granting the request put forward by Ms. Hofmeyer, but you would like to request that if that request is granted, she should question Ms. Memela after you have finished the re-examination? Is that your position?
Let me rephrase. I see my client nodding.
Yeah, your client is nodding, I can see.
Yes, but it's a two-pronged approach.
She's giving you instructions.
Yes, she's giving me, yes, thank you. That's why I'm pointing it out, Chair, because
Yeah.
ethically I must follow her instructions. But there is also something which maybe, before I come to the next one, let me just start first on a one which is a legal issue. And the legal issue is, when we received this request, it took us by surprise. Ms. Hofmeyer has made an address here. And the reason why it took us by surprise is the fact that we couldn't see any basis. And the reason why we are saying that there is no basis is because after Mr. Nzeko had given evidence,
Chair, if I may just interject, I do apologize, Ms. Mbandwa. I've just been told that the sound quality is
bad.
particularly bad, and so transcription of what Ms. Mbandwa is saying is not going to be ideal. I wonder if I should
Yes.
not leave the
Yeah,
podium. We'll
let's do
sterilize
that.
so
Yeah.
that it's safe for you to
Let's do
approach.
that, yeah.
And then you can complete your submissions here, Ms. Mbandwa.
thank you, Chair.
I may just mention to you, Ms. Mbandwa, so that you know exactly what's in my mind. I can mention to you that after I'd had Mr. Nzegu's evidence, without the legal team making any request, I said to myself, well, it will be important to hear what Ms. Memela has to say about some of the evidence that emerged during Mr. Nzegu's evidence. So with or without the legal team making a request, I was going to want to hear Ms. Memela's side of the story on some of those things.
Thank you, Chair, for advising of your view already. But I was still on the point of saying, this request caught us by surprise, and the reason is simple. It's because of what Ms. Hofmeyer has said, the fact that these proceedings are inquisitorial. When a request was forwarded to us to say Mrs. Memela must submit an affidavit, we took the view, having listened audio of Mr. Mbandwa, if there is any dispute about this, because it is a letter that was sent on the 21st of September or dated 21st of September, and paragraph 8 provides as follows. In the event of her failure to provide a version, Mr. Nzeku's evidence about her involvement will be undisputed. Now, if we accept that these are inquisitorial proceedings, and if we accept that we run the risk, and that is the risk of saying that if we do not file an affidavit explaining Mr. Nzeku's evidence, as they stated here, they said that her involvement will be undisputed. Our understanding now is this, and it comes from purely a question of procedure. And again, before I go to the question of procedure, it goes to what Ms. Hofmeyer said to us when we had an interview with her. She said, I, as Ms. Hofmeyer, am a lawyer for the public. I'm not your lawyer, Mrs. Memela, or I'm not your lawyer, whoever comes as a witness before the Zondo Commission being an accused. So which means therefore that these people come represented by people like us, they are legal advisors. It is for that reason why now I'm surprised at the volte-face of Mrs. Hofmeyer when she says now she wants to again cross-examine Mrs. Memela in order to protect Mrs. Memela or to assist Mrs. Memela. We are saying no, we know for a fact, because she is on record as saying that she is not going to assist any Mrs. Memela because she is a lawyer for the public. So we are raising that because it is going to be important when we do the re-examination. When we go discuss evidence and documents which we are going to submit here, which we know are already with the Commission and have not been put forward in the public hearings at least. Now, we are now coming to the inquisitorial nature of these proceedings. We are saying, if Mrs. Hofmeyer has already made a conclusion, because she did make that conclusion when the evidence of Ms. Nzeku was led, because she said that Mrs. Memela assisted Mr. Nzeku by selling the GPUs to her daughter. And then she again made a conclusion. She said that the fact that there was a date of 2019, it means that is fraud. So she has made these conclusions. And now I'm saying, now that she has made these conclusions, which obviously are going to fit into the report that is going to be made by the Commission to the SIUs, that is the Special Investigation Unit, what is the purpose now to be gained by now again examining Ms. Memela? And then now coming chair again, if this was an ordinary court of law, I know it is not. I know that the Commission, you as the chair of the Commission has a discretion on what to allow. But again, because at the end of the day, we're talking here time, and for us, especially for me, time is money. Now we've got a question we ask. What is it that is going to be served by Ms. Hofmeyer asking Mrs. Memela these questions? And we're asking that question.
Ms. Mbanjwa, a lot will be served by me getting certain clarification from Ms. Memela.
Yes, Your Worship, just to put these things.
It will help me a lot.
Thank you, Your Worship.
To hear, yeah.
Thank you, Worship. You having said that, and I respecting you as the chair of this commission, I still need to put it on record. And the reason why I'm putting it on record is because at the end of the day, when the commission is done and dusted, a certain kind of jurisprudence will have to come from the hearings of these commissions, which is why I'm now putting on record and saying that generally in a court of law, if a person wants to reopen, because that is what basically they are doing, they are reopening. I know that she says because of the fluidity, but still there must be a basis. Now, if these things are going to be forwarded to the
basis is that when Ms. Memela gave evidence previously in February, Mr. Nzeku had not given evidence, and subsequently Mr. Nzeku gave evidence which raised certain issues that relate to the issue of the sale of land. And Ms. Memela had explained the payment of the 2.5 million rand on the basis that there was a genuine sale of land.
Yes, but Your Worship, the point is, these issues were traversed already.
Sorry?
These issues were traversed already with Ms. Memela.
They were not traversed in the light of Mr. Nzeku's evidence.
But Your Worship, but Chair, it is not going to be the commission that is going to make a finding of guilt. If this was a criminal court, there would be relevance, because then procedurally this testimony would be flawed, because what would be said? It would be said to Ms. Hofmeyer, Ms. Hofmeyer, you did not put the version of Mr. Nzeku to Mrs. Memela. In this case, that difficulty does not arise. And why I'm saying that, Your Worship, is that we would love to move to more important things because we need the time to re-examine. That is that. And then now coming to the other issue, because you have already advised me, Your Worship, that you were also of the inclination to want questions from Mrs. Memela. If you should choose to do that, then, Mr. Chair, we want now to plead as follows. We have all seen, we've been here with Ms. Hofmeyer, there is a problem with time. If Ms. Hofmeyer is allowed to go in first, what is going to happen is that these questions are going to be long, and our 2 hours is going to be exhausted. We're already at 3 o'clock. My understanding is that the commission finishes at 5. We want to confine ourselves to the 2 hours, and in order to do that, we want to go in first, so that we limit ourselves to our 2 hours, we do what needs to be done, and then we are done with it.
I guess the sooner we start, the better.
As it is.
Is that
So-
all right?
Yes.
I
So
think
are we beginning now, Chair?
I think we must begin. I will grant the request.
You have granted the request. So who is going to start first? Because there was the
Ms.
second.
Hofmeyer must start, and then re-examination will come after.
Okay, as it pleases. Thank you.
Yes, thank you. Let's talk about how much you envisage, how much time you think you might need to question Ms. Memela, Ms. Hofmeyer.
Chair, on the last occasion of Ms. Memela's questioning, I anticipated a day and it ended up taking 3.5. So I'm clearly a fairly unreliable estimator of time. What I can say to you is it's a very focused set of questions. It relates to the evidence of Mr. Nzeku. It relates to what Ms. Memela has been reported in the media as having said about that evidence, because we have not obtained from her any version prior to today. So I just need to begin by getting clarity from her as to what her version is in response to Mr. Nzeku, and then to probe matters around it. We're now at 3 o'clock. I imagine being able to take an hour or a little bit beyond that. But Chair, I do know that you also have indicated that you have questions. So
Well, I might not have lots of questions, but let's see how it goes. Let's see whether we are able to. You may be able to cover everything within 45 minutes.
I will give it my best
If there's a
endeavor.
challenge, we can
Absolutely.
we can look at time later on.
Thank you so much.
Okay, all right.
Thank you, Chair.
Oh,
Ms.
I think the oath must be administered
Please.
again, because there's been a lot of time that has lapsed. If there is somebody who can give,
I have a
is
spare
it for
pen.
the witness, for yourself, for your witness?
Can I just ask
You are fine,
Rev.
okay.
Stamela to sterilize it, and then you can take my pen.
Okay, all right. Thank you. Please administer the oath of affirmation.
Please state your full names for the record.
My name is Nontsasa Memela.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. Chair, there's just one point of clarification. I understood my learned friend, Ms. Mbanjwa, to indicate that there were certain documents she wanted to traverse with Ms. Memela. It would certainly be necessary for us to see those documents before re-examination, unless they're documents that already form part of the bundle. So I just want to mention that as a procedural matter. Ms. Mbanjwa can provide those documents to us in due course, but we would need to have seen them before the conclusion of Ms.
Yeah.
Memela's questioning. Thank
Okay,
you.
all right.
Ms. Memela, I indicated earlier that there had been some media reporting after Mr. Nzeku's evidence, which appeared to indicate your response to his evidence. I'm well aware that the media often gets quotations incorrect and persons' positions incorrect. So I'd like to take you to the one article that we did come across. And you'll find that in the bundle that's been placed in front of you, DD25C. Ms. Memela, they're just behind you. DD25C.
Shall we change this on the spine from exhibit to bundle,
Yes, thank you, Chair.
as we did with the other one?
Yes.
So this file will be bundle DD25A.
This is now C because A and B were already entered into the evidence when Ms. Memela testified in February. So we now need C.
He's giving me another one.
Yes.
So this one is with A. So I just wrote bundle instead of...
That's fine.
exhibit.
Bundle, and now we'll do bundle DD25C, which is the new one. Thank you, Chair.
So this will be bundle DD25C.
Yes.
Okay.
If you go right to the back of that
Or
bundle.
should it be 25 without the C on the basis that what's inside may be A, B, C, D?
Well, what has happened is we originally in February had bundle 25A and B.
Yes.
Those were the bundles that contained the documents relevant to Ms. Memela's evidence in February.
Yeah.
Since then, we've obtained the affidavit of Mr. Piri, which was
Yes.
not available in February, which I indicated previously has been provided. So we placed in bundle C
Yeah.
Mr. Piri's affidavit,
Yeah.
and then certain further documents, including the one I'm going to take Ms. Memela to now. And so it was just to keep the sequence that we
Okay.
identified this file as
Yeah.
25C,
Okay,
with
all
your
right.
leave.
Okay.
So if we go right to the end, it's page 1144. It's about 3 pages from the end.
Yes, I've got it.
Thank you. And Ms. Memela, I take you to this only because as I stand here today, I don't have a version from you on Mr. Nzeku's evidence because the opportunity was offered for you to provide an affidavit and you declined that. So the only reference point we had
Sorry, Chair, because unfortunately I have to object. When an application was made to question Mrs. Memela, it was confined. It was to be on the evidence that was given by Mr. Nzeku. Surely what the media writes cannot form part of
No,
the
Miss
inquisitorial
Mbandwa,
process.
no, please, let's make progress. Continue, Ms. Hofmeyer.
Thank you. So this is the version that the media reports you as having given to them. If you turn over the page at 1145, you are quoted as having told Times Live the following. It's in the second paragraph. The inquiry's investigation team did not ask the correct people about the land. They asked the Cholani family, which is where my mother was born, instead of asking the Manzi family, where my grandmother was born. Can you confirm that you gave that quotation to Times Live?
Chair, you
Yes,
already
Ms.
know my
Memela.
problem.
Yes.
I'm unable to directly answer a question without giving a background. And I will give you the reason for that.
Well, hang on one second.
Okay.
One of the reasons why we took as long as we did last time
That's because of
was that there was too much background. So, as I understand the question here is a simple one. There is a quotation attributed to you by this publication, and the question is whether that is what you said or not.
Oh, that's what I said when I asked for my
Yes.
opportunity to state my side. Yeah.
You did say
After-
that.
Yes.
Thank you.
Okay.
And then later on in the page, middle of the way down, you're responding to the work that was done by the handwriting expert. And you're quoted as saying, middle of the way down, my mother had no signature. Instead, she would write her initials and surname where she was supposed to sign. For the inquiry's handwriting expert to compare how she wrote her name more than 20 years ago, when she did an affidavit for me to get an ID, versus her writing in 2015 can never be considered as a reasonable comparison. Even I do not write the same as I used to write 20 years ago. Is that what you said to Times
That's what I
Live?
said.
Thank you. And then just 2 more paragraphs down, you are quoted as having said, the evidence leader is pushing her own narrative of making the public believe Mr. Nzeku paid me to help him with a tender. I'm still trying to understand which tender I gave to Mr. Nzeku, close quotations. Is that also something you said to the
Yes.
media? Thank you. So I'd like to take each of those matters and probe them a bit further with you, if I may, Ms. Memela. So the first criticism, as you relayed it to the media, of the approach in Mr. Nzeku's evidence was that the investigators of the commission had dealt with the Cholani family as opposed to the Manzi family. Is that correct?
You said Cholani, Chair.
Is it pronounced as Tolani?
Cholani, yes.
I apologize, Cholani.
Yes, Chair,
Yeah.
I would expect that because last time I was repeatedly corrected when I said Hoofmeyer instead of Hofmeyer, so
Yeah.
I would like the balance.
Yeah.
It's Cholani.
Cholani,
Yes.
thank you. So your criticism was that the investigators had focused on the Cholani family and not the Manzi family. Is that right?
Yes.
Now, I'd like to explain to you, with reference to the documents, why the Cholani family was chosen to focus on. And that's because of the affidavit that your mother purportedly gave in September of 2015. Are you aware of that?
I'm aware of that.
Yes. And are you aware that the affidavit says that I inherited the land from my mother, my parents, Mr. and Mrs. Cholani? You're aware of
Yeah.
that? Please say yes. Just because the record doesn't reflect a head
I said
nod.
yes.
Thank you. So the investigators went to investigate the version of your mother, if it was her version, on an affidavit indicating that she had inherited the land from her parents, the Cholanis. Is that right?
Okay, are you asking me what the investigators followed?
No, I'm explaining to you that the reason why they went to investigate the inheritance via the Cholani family is because of what your mother wrote in her alleged affidavit. Do you accept that?
I accept on the affidavit, but I'm not sure if the investigators should follow just one suit.
So one source being the source of your mother's alleged affidavit. They shouldn't have focused on that.
No, I'm not saying they shouldn't, but I'm saying they shouldn't be limited to that, Chair. Because my understanding of the investigation is that you look at all the surrounding circumstances to ensure that you get to the bottom of the issue that you are looking for. Instead of just taking just one document and focusing on it and say, okay, this is what I'm going to follow. Yes.
So just be clear with me, what is the criticism of going to investigate the land held by your mother's parents, Mr. and Mrs. Cholani, if what she said in her affidavit related to the sale is the land is fully owned by me and I inherited it from my parents, Mr. and Mrs. Cholani? Can you explain what's then problematic about focusing on that?
Okay, so I must explain my criticism now.
Yes, please.
Okay. Chair, my understanding is that you also coming from the villages, your background, or?
I grew up in villages.
Yeah, okay. Yeah, so I just wanted to understand that because I know Ms. Hofmeyer doesn't. So, when, in the villages, when you talk about land belonging to somebody, it's different from talking about the land in Braamfontein or in Bryanston, which will have a title deed that has got the name of who and yeah. So when my grandmother and her parents moved to El Fafa, they were coming from Mbindwini, being the Manzi family, and then she got married to the Tolani family. So when she got that land, my grandmother, because being the elder daughter of her parent. So then it becomes the land of belonging to her and her husband, July Tolani. You understand? So that's why I'm saying if maybe they had if it was not meant as a bad intention, if they had asked maybe, or as they like sending questions and say, okay, exactly which family should we talk to regarding this land? Which family will be able to go and point out the land that you're talking about? This is the same, Chair. I will raise the issue of Chief Sitao as well, that after watching Mr. Nzegu's testimony, my understanding is that the investigators of this commission should have, I don't know if they have, but by listening to the testimony, there's nothing that gave me this impression that they had asked Mr. Nzegu first, have you met Mr. Chief Sitao? And then went to Chief Sitao based on what he has provided. Instead, they went to Chief Sitao and then come with an affidavit, let him sit here without going through an affidavit, and then put a question to him after, to confirm on the affidavit that was found without actually confirming to him. So that's where I was going with this whole thing. It was not a criticism per se, it's just that I was taken aback with the way Ms. Hofmeyer was actually putting her questions across, like saying, I put it to you that this, I put it to you that this, as if it's based on facts, which is we sitting here, I actually have facts that can actually justify what happened, yeah.
Ms. Hofmeyer, continue.
Thank you. So your mother, when she described, if this is her affidavit, the land she was selling, said that it was land fully owned by her, inherited from her parents, Mr. and Ms. Holani. Are you aware of that?
Yes.
She then described it. She said it's the land situated at Empondweni next to the Umzimvubu River in Tabankulu. Are you aware of that?
I'm aware of that.
That's the land that she allegedly sold to Mr. Nzeku. It's land in the area over which Chief Sikau administers, and he confirmed in his affidavit to the Commission that he'd never met Mr. Nzeku, and he was aware of no transfer in relation to land falling within that area. Are you aware of that evidence?
I will not say yes or no on that question, Chair. The reason why is that after requesting certain documents, the affidavit of Chief Sikau was also provided to us, and we went through that. And what Ms. Hofmeyer is saying now to the public is that Chief Sikau said that's his area, and he has never met Mr. Nzeku. And my understanding, of course, Chief Sikau would not meet Mr. Nzeku for demarcation of land or sale of land. Chief Sikau, my understanding, Ms. Hofmeyer, just to give you clarity, is the paramount chief of Amambondo. We've got two paramount chiefs of Amambondo. Sikau and Ndamase. And not even once, Chair, where you would see the paramount chief going and meeting people who are coming maybe to buy the land or the demarcation and stuff. I will tell you now, Chair, I have a land, I have a home in Sugarbush. I have never met the paramount chief. But the person who usually is involved there are the representative of the paramount chief, being the headman, and in Xhosa we call them ibhodi sometimes. Those are the people that actually sit there and discuss and stuff. But when it comes to selling the land, Ms. Hofmeyer, in the rural areas, you don't require a permission of a paramount chief. You don't need to see a paramount chief. And I even made an example of this. It's a pity that Ms. Hofmeyer, maybe, or the investigators never really went back to my statement, because they would have seen where I said, when you sell the land, you don't need anybody's permission. My husband and I can actually decide now that we are selling the land in Sugarbush. We won't even have to notify the body, the headman. The only time that we'll notify him is when the new person is coming now to take over and stay and say, okay, now this is going to be the person or the owner of this. But there is no paper.
Ms. Memela,
Yeah.
how do you talk about selling a piece of land in the context of land that is administered by a chief or inkosi? Because that land is not yours in the true sense. You are allowed to occupy it, And if you should leave the area, the local chief or inkosi can allocate it to somebody else. At least that is how things happen in
KZN.
in KZN. I'm under the impression that it's the same thing elsewhere.
No, Chair, I'm sorry, I'm not saying, I will not say the whole judge is lying. I will just say, maybe you have limited information about the land in the villages. There are so many people that sell land.
Well,
all
I
the
know
time.
that even in KZN, people speak about selling.
Yes.
But my understanding is that legally, if it's land falling under an inkosi or chief, that sale is not valid in law because it's not your land in the same way as in the urban areas. What you can do is you take this person who wants to take over your house or where you were allocated by the chief. You take him or her to the local chief to say, I'm going to be leaving this area. My children live in Umlazi. They've said I must go and live with them now because I'm old. There's nobody to look after me here. But here is somebody that would like to get into this land. And if the chief approves, then the person takes over. But the chief could refuse. Yeah.
Yeah, Chair, remember I had said to you, Chief-
Ms. Mbanjwa, what's happening now?
Oh.
Yes, but leave the witness to deal with that, Ms. Mbanjwa. When you re-examine her, you can try and get her to give whatever clarification. Well, let's hear from the witness who says she knows how these things happen in the Eastern Cape. Yeah, no, that's fine. You'll give me assistance when you re-examine. Yeah.
Okay, Chair, you spoke about then it makes it not legal to sell, and now as Ms. Major had raised the issue of now we're talking legalities, and we don't want to waste the Commission's time where we actually explain the Alienation of Land Act and how it applies in the rural areas.
Yeah.
But we will cover that during the re-examination. But when it comes to the chief, as much as I'm not the party in the deed of sale, it's my mom and Mr. Nzeku, but my understanding is there is no way that Mr. Nzeku, yes, he said he went to Eastern Cape and met some people, but I'm sitting here, I'm saying there is no way that he met Chief Stau because the paramount chief does not sit in sale of lands and demarcation of land and all those kind of things. So he may have met the headmen or the other people that maybe are representing that area. Yeah. And when I read the affidavit of Chief Stau, Chair, he's actually explaining that okay, there are certain people that represent that area, and he mentioned Ms. Nongubela Ndlebe, who I found out that in 2015, actually, she was not the chief by then. So you see, so that's where now the problem is, where I say, if the Commission, in terms of, because now Ms. Hofmeyer talked about fairness, if the Commission had done this thing fairly in saying, okay, Mr. Nzeku, you said you went to Eastern Cape in your affidavit, you bought the land and stuff. Who did you meet? Mr. Nzeku is not coming from Eastern Cape, Chair. He's coming from Johannesburg. That's my understanding. He's not coming from that area, right? So for him to be expected to remember people that he met between 2015 and 2016, right? I'm just, let me finish there. And then, I would have expected the commission's
So are you
team-
saying that when he said he met Chief Stau, he must have been mistaken because
Chair.
he could not have met Chief Stau?
He could have not met Chief Stau, but let me tell you, because I was watching the testimony and I was taking notes. Because I knew that somehow maybe I would have to come and give clarity. The question was put to him, but I wanted to address the issue of asking him first before going to him, but it's fine. The question was put-
Let's do it this way.
Yeah.
Ms. Hofmeyer, this question, you might wish to deal with it now or leave it later on and deal with others. Can I just leave
Thank
it to
you.
you? So I just want us to make progress.
Of course.
I don't want us to sit with what happened last time.
Yes,
Yeah.
indeed. Or reinterpret what happened last time. Today is for Ms. Memela to tell us what she knows about the events, right? So you received Chief Sikhau's affidavit, Ms. Memela.
Yes,
You've read it, have you?
we've gone through it, yes.
Yes. Do you disagree with any part of what he says there?
I disagree with lots of things that he had said. Yes, and that's exactly what we had prepared, Chair, to cover in our re-examination using the Alienation of Land Act. So I don't know if you would like...
Well, the re-examination wasn't going to cover areas that had not been covered by Ms. Hofmeyer.
Of
So-
course, yeah.
You see, because what Chief Sikhau describes is exactly what the chair has put
Can
to
we go
you.
back? Can we go to... Are you sending me? Are you-
No.
Okay, can you go to that? Because you're saying...
No, just hang on, Ms. Memela. She will
Okay.
tell you if she wants you to open to a particular page.
Because the chair a moment ago gave you an understanding of how, I'm going to put sale in inverted commas, because the point as I understood it that you made, Chair, was that sales per se do not take place. It's permissions to occupy that require the authority to have been given by the traditional council. And
Yes,
that's an
exactly.
aspect that Chief Sikhau dealt with in detail in his affidavit. Do you recall seeing that?
I recall seeing that in the
And do you
affidavit,
say
Chair.
that he's wrong?
I say he is wrong, and will prove that.
Yeah, well, certainly I'm familiar with permissions to occupy as well.
And
Yeah, okay.
we can move from that to the issue in relation to the handwriting expert, because I understand you have a difference of opinion with Chief Sikhau about how transfers take place. Is that correct?
That's correct.
Do you take issue with Mr. Nzeku's evidence which changed over the course of the day? He first said he had met Chief Sikhau. He then later admitted that he hadn't. Which version
Sure.
do you say is correct? Do you have any knowledge of it?
Chair, as I listened, because remember, when you are listening versus when Ms. Hofmeyer is questioning, remember, I don't know if she listens to her own line of questioning, but I remember when she raised this question, she said, Mr. Nzeku, did you meet, when you went to Eastern Cape to view the land, did you meet the chief? And Mr. Nzeku said, yes, I met people, and I met the chief. And the following question was the chief Sikhau? And the answer of Mr. Nzeku, I even wrote it down. He said, I met Chief Sikhau, I think so. He said, I think so. Because I'm sure he had not seen even the affidavit at that time. You understand? So like it was actually put to him. So there's, to say then a person has agreed, as if he's the one who actually started and say, okay, I met the chief. I would say, Chair, the person agreed when he said, I went to Eastern Cape, viewed the land, and I met Chief Sikhau. But the Chief Sikhau part was put to him. And he responded and said, I met the chief, I think so. And then the next question.
Is
he
there
said,
another
I think-
chief other than Chief Stau
Yes.
in that area?
Yes.
Who is the other chief?
It's Mr. Ndlebe. During 2015, it was Mr. Ndlebe, and now from 2016, it was Ms. Nonqubela Ndlebe.
Is he a chief or is he a headman?
They are called chief, but of course, it's that they are representing the certain areas, like which is one of them is Mbindweni, Lufafa, and all the other areas. Yes.
But it was Mpindweni land that your mother allegedly sold,
Yes,
correct?
yeah.
And Chief Sikhau says that no land at Mpondweni that devolved to your mother ever came to his attention, and he never granted any permission for it to be sold. Is
Yes,
that correct?
I saw that, Chair, in
Yes.
his affidavit, that it never came, it went to his attention. So of course I cannot deny that, that, okay, it never went to his attention, but the fact that the sale happened, it happened.
No.
And there is no law that says, okay, it should go to his
I'm
attention.
sorry, you said the fact that, and then I didn't hear what you said.
Okay, I said I don't deny when he says he was not made aware of the sale. You understand? Because I'm not sure about that. But all I'm saying is that for him to say for the sale to go through, he has to give permission. That's the part that I'm disputing.
That
Well-
you are disputing.
Yeah.
Well, he doesn't say he has to give permission to the sale. He himself says it's not correct to think of it as a sale. The only thing that can be granted is permission to occupy, and no permission to occupy for Mr. Nzeku taking over land in Mpondweni ever came to his attention. Do you accept that that's what Chief
That's
Sitao
what the
says?
affidavit says, yes.
And can you also confirm you have no knowledge of who attended any meeting with Mr. Nzeku in the Eastern Cape, because you did not
I
attend
was
that
not
meeting?
there, yes.
Thank you.
The land
Yes, Chair.
that was said to have been sold falls within the area under the jurisdiction of Chief Sitao, is that right?
It falls under one of the districts under him.
Yes,
Yes.
yes. Now, I assume that that would mean that if there was somebody else other than him who could do something about giving somebody that piece of land, or whether you call it selling or granting permission to occupy, that person would be one of the people who are under Chief Sitao.
Yes, it will be.
It
what?
would be like a headman, maybe a headman.
Headman, or
yes, yes. Now, that person could not be administering the giving of land to people legally in a manner that is not known to Chief Sitao. If Chief Sitao says, under the land that falls within my jurisdiction, you can only be granted permission to occupy. You can't be granted anything stronger than that legally. It must include all the areas under him. Otherwise, he would say, certain areas you can be granted permission to occupy, but others you can get the land sold. So, as I understand his affidavit, he seems to suggest that when you talk about land that falls under my authority, and that means including Izinduna, headman under him, this is what we talk about when we give somebody land. We talk about permission to occupy. That he must be talking about all land under him.
Chair, what you've just described here is a process that actually follows a certain registration process and procedure.
But I'm taking the process that he is talking about in his affidavit. He, as I understand it, and Ms. Hofmeyer will tell me if I've misunderstood something.
No, yeah.
Permission to occupy is the only system he is talking about that, in terms of which somebody can be granted land under him. Is that not so?
It's not so, Chair, and I can tell you now, land gets sold in Eastern Cape
No.
several times.
No.
And
let me say, when I say is it not so, I'm asking not what the position is as you understand it.
No, as
I'm
I
asking
understand it, yes.
whether that is how he explains it in his affidavit.
Yes,
You accept that,
I accept
but
that.
you say you don't
It's
agree
not how-
with him.
yes, it's not how it works,
Okay, all
yes.
right.
Thank you. Let's then move to your second issue that you took up in your interview with the media. That was the issue of the handwriting experts report. You've received that, have you?
Sorry?
You've received the handwriting experts report.
Yes, we've received on the bundle.
Did you notice that she was not asked to compare the signatures on the affidavit and the sale agreement with the handwriting of your mother from 20 years ago? She was asked to compare it to the handwriting of your mother as recently as a year before the alleged affidavit and sale agreement was entered into.
So if I remember correctly, when I looked at that report, it's just that I don't have it now here, but when I look at that report of I'm not sure if I must, When I look at that report, there is the initials of my mom and surname from 1997. Now tell me if that's not more than 20 years ago. So they started 1997, there's 2010, I think there's 2014, I'm not sure, maybe I might not remember. I'm just trying to remember the comparison, which is I'm thinking they were comparing documents as back then. And I remember Ms. Hofmeyer saying in the public platform that the signatures, according to the expert, the signatures of Ms. Hlohlela had been consistent way back. And when I saw the document, there is no consistency, exactly as I had said when I responded to the journalist that I was talking to, who actually wrote something different. I noticed one thing, that when sometimes she would write N Hlohlela, sometimes she would write NG Hlohlela, sometimes she would write G Hlohlela. You understand? So I'm not sure then where is the consistency there. That's where I was actually trying to understand that then what I saw here, in comparison to what I said in this, it's actually exactly the same, because that's what I saw.
Yes, but
there is no
the
consistency.
question, Ms. Memela, was whether you had noticed that the comparison included your mother's signature a year before the affidavit.
Yes,
You
but
noticed
starting from
that?
20 years back, yes.
Yeah, okay.
Yes, but your criticism of the investigation was that all that Ms. Buckley had done was taken the affidavit and compared it to a signature from 20 years ago. Do you accept that that is wrong?
Okay, yeah, because remember I had not have the document then.
I'm just asking
Yeah,
you now, do you
yes,
accept
it's
that what you
yes.
said to the media is wrong?
It's not really wrong, but I'm just saying I know that you compared from way back.
No, how can it not be wrong? Your statement to the media was Ms. Buckley's evidence should be rejected because she was comparing your mother's signature on the affidavit to a signature from 20 years ago. Correct?
It should be rejected. Did I say that? Is that how I'm quoted saying?
No, I'm paraphrasing.
Thank you. Like you see now, when you changing the statement and saying something that I didn't say, that's not fair. Okay. The other thing,
Yes,
in
but
terms
what is,
of the
what is clear,
expert-
I'm sorry, Ms. Memela, what is clear is that you were rejecting the conclusion of the expert witness, of the handwriting witness. That's clear from the article.
That is clear, and also,
Yes.
Chair, after receiving the documents that show the report of this lady, there is a disclaimer there that Ms. Hofmeyer chose not to read for the public to see.
No, you're
understand?
going to something else. Let's go step by step.
Okay.
You accept that in the article, you criticized the expert, handwriting expert, on the basis that she did not compare, she did not use recent signatures. She looked at signatures that were 20 years or more old. Is that right? You accept that that was your criticism?
Okay, can you take me back there, Ms. Hofmeyer?
It's page 1145 in the middle of the page. I'll read it into the record just for convenience. What you are quoted to have said is, for the inquiry's handwriting expert to compare how she wrote her name more than 20 years ago when she did an affidavit for me to get an ID versus her writing in 2015 can never be considered as a reasonable comparison. Even I do not write the same as I used to write 20 years ago.
Yes.
So the question was, do you accept now that the expert did look at more recent signatures, namely even one that was a year before the affidavit.
Yes, the expert, after I saw the document, he has looked at, I think, about 4
Yeah.
different signature of my mom.
Also,
But-
now you accept.
Yes, but Ms. Hofmeyer said in public.
No,
that
leave out
there
what
was
she said.
consistency.
Leave out what she said.
Okay.
So you accept now that the handwriting expert had looked at more recent signatures.
It looked at 5.
Yes.
Yeah.
And
And
Ms.
there was no
Hofmeyer's
consistency.
question was therefore, you should accept also that it was not correct to suggest that she had not looked at recent signatures. She had only looked at
That's not what I
a
said.
signature that was about 20 years old.
That's not what I said, Chair, that she has not looked at recent signatures. I talked about 20 years and 2015. Of course, 2015, that's the last one I think I know that my mom, they had what I referred to. Ms. Hofmeyer actually said this, you see, so on public, in public.
Yeah,
Exactly.
I'm not asking about that, what she said in public. I'm just asking about what she was asking now. Ms. Mbanjwa? Sorry?
The reason why we are objecting to this, the witness is struggling because the concession that she is supposed to make is not what she said. What she said, what the expert said is, her mother's handwriting has been consistent throughout. And she said that consistency can never be there because even her own mother's handwriting, which was when she was getting an ID, and the one in 2015 was different. So it's not as if she said, and now, what she is now demanded to do now is to make a concession that when she spoke to the media, she unfairly criticized the commission. And the other reason why I object to that kind of questioning is because it has got nothing to do with the mandate of the commission. It has got something to do with the integrity of the commission. And the truth of the matter is, these hearings are televised because people are going to criticize them. It's just a fact. So if we are going to come here and worry
Ms.
because there has been
Mbanjwa,
criticism.
Ms. Mbanjwa, fraud and corruption is in the terms of reference of this commission.
Yes,
Please
but-
continue, Ms. Hofmeyer.
But
Thank you,
not
Chair.
not the criticism of how the question is done. This is not about fraud and commission, Chair. It has moved now. It has become now a personal issue that either the investigators of the commission or whatever. So we are busy now with the fact that the expert...
Ms. Mbanjwa, please sit down.
Thank you, Chair.
Continue, Ms. Hofmeyer.
Thank you. Ms. Memela, are you a handwriting expert?
Of course I'm not.
So do you have any basis to dispute the conclusions drawn by Ms. Buckley, who is a handwriting expert?
The basis that I would have to reject that is the fact that...
Could you just answer the first question first? Do you reject the conclusions that she
I
draws
reject-
in her
I
report?
reject them. I
Can
may
you
not be an
explain why?
expert, I reject them. Can I explain why?
Yes, please.
Sure. Ms. Hofmeyer did not read the disclaimer when she made that statement from that report. We just recently saw the disclaimer from the expert, handwriting expert, where she said it should be known, of course not word for word because I did not memorize that, but she said it should be noted that she had made comparison of the copies. We're talking about handwriting here, Chair. She made comparison of the copies, not the original. When you're talking about where you're trying to make sure that is this Nonsasa's handwriting and stuff, the only 100% accurate result is when you compare originals to originals. She even explained that when you compare copies, especially you compare copies with difference in years, the font changes. She said that
In Mr. Nzeku's bundles.
DD 2060.
Just
It's
tell her
B-
one again.
Sorry, DD 20. So her conclusion appears at page 298.
Sorry. Apologies, Mr.
You have not found it.
I'm just going through it, and I had a request, Chair.
Well, don't go through it. Wait for the question. The question might not need you to go through it.
Chair, I don't want to go through the whole of them. I might not say
Yeah.
it. Yeah.
Let her continue with her question. If she wants to go to the disclaimer later, she can do so. If she wants to start there now, it's fine.
Okay.
I'm happy to go to the disclaimer. Please read it through into the record. What page are you at?
I'm page 295.
Thank you. And what is the disclaimer?
Can I read, Chair? Yeah. Copies of the documents were submitted for examination, although a clear digital photocopy can yield almost as much information as the original. Repeated copying affects the quality of the writing and printing. A first-generation copy, in brackets, copy from original, will display slight loss of minute detail and some pixelation in the lines. A copy of a copy will have more loss of definition and more pixelation. The lines lose more definition with each subsequent copy, and the quality of the printing and writing get progressively worse. The pen pressure of writing cannot be assessed on the copies. The possibility of electronic manipulation, e.g. cut and paste and or disguise, in bracket, glossary, cannot be excluded on copies. This examination is therefore based on the aspects of the writing that can be discerned despite the copying. All documents have been examined with aid of microscopes and measuring instrument.
Yes, so that's the disclaimer.
Yes.
She says, for example, she can't assess pen pressure because she's dealing with copies, and she says that her examination is therefore based on the writing on copies. And she goes to her conclusion at 298, and she says the following. Although copies were examined, the dissimilarities or similarities in individual writing characteristics are profound. A, it is my professional opinion that the question signatures were not made by the same writer that executed the known to be genuine signatures, NG Hlotlela. B, all the writing on affidavit that was questioned 1 and sale agreement question 2 was done by one and the same hand. The individual writing characteristics present in the writing on the question documents are also present in the Q1 and Q2 signatures purported to be by one NG Hlotlela. Do you see that?
Yeah.
Ms. Memela, I put it to you that that conclusion is entirely consistent with the disclaimer. The disclaimer says there are limitations to assessing copies. I've taken those into account. For example, I haven't looked at pen pressure issues. But despite the fact that I'm dealing with copies, there are, quote, profound characteristics that are dissimilar. And she nonetheless concludes in her professional opinion that the question signatures were not made by the same writer as the known to be genuine signatures. Do you dispute that conclusion?
I dispute that.
And the basis is because of the disclaimer, is that correct?
No, on the basis of the disclaimer plus on the basis of the fact that I know that the handwriting of my mom kept on changing as she signs, as the year goes by.
Yes, that's
Yeah.
even reflected
Yeah.
in the examples that she attaches. She changed initials over
Yes.
time, correct? And despite that, in her professional opinion, she concluded that the signatures on the question documents, affidavit and sale agreement, were not from the same hand that gave all the other genuine signatures over time. Do you accept that that was her conclusion?
You're saying that gave all the other genuine signatures all the time?
Over time.
Over time.
The genuine signatures, remember,
we
went
read
from
that?
1997
Yeah.
to 2014.
Okay, can we go back there? Can you show me? Can we go
Where
to that document?
we're looking at it.
No, where there's my mother's initials and surname.
Yes,
Which,
it's over the page. You go to page 300. That's part of her report. You see, the first two are the question signatures, Q1 and Q2, and then you have ST7, ST5, ST6, and ST2. Those are the ones that are taken from 2014, 2010, 2010, and 1997. And she says, in her professional opinion, question 1 and question 2 signatures were not written by the same hand that wrote all of those other signatures over time.
are you where we are? It's page 300.
Yeah? I think so.
Yeah, I may not be an expert, writing expert, but the consistency that Ms. Hofmeyer keeps on referring to, saying like, okay, it happened in 1997 up to 2014. For instance, from my side, I can say the N is different. The
Ms.
H is
Mamela,
the-
you've
No,
already
but,
confirmed you're not
yeah,
a handwriting
yeah.
expert.
Exactly. Then I think, Chair, it's either after speaking to my lawyer, we'll request that we also take this through our expert so that we can submit something professional from an expert. But I'm saying I'm rejecting it from what I see.
Ms. Mamela, you were given this over a week ago. If you wanted to contest it, it would have been appropriate for you to have introduced that today, would it not?
It was received.
Do you want me to give you the date? It was provided on the 14th, sorry, it was provided on the 14th of September. That's much more than a week ago.
That's 2 weeks ago, or just a little over 2 weeks ago.
Over 2 weeks.
So does that mean, Chair, we are not allowed to get an expert now since we're given this more than 2 weeks ago?
Well, you can make the request, but what
Okay.
Ms. Hofmeyer is putting to you is that you had an opportunity after you were given this to ask an expert, handwriting expert, to do the same and
Chair, let me
have
give
the
an
report.
explanation for that, hoping you understand. The reason maybe that we didn't act within the 2 weeks that we were given this document is that I'm not party to this, to the sale and also an affidavit. Therefore, I didn't know that I could be allowed then to be the one who confirms and go and get the expert, writing expert to. So if it is allowed for me to do that, then I would appreciate that.
Okay, Ms. Mbandwa.
I just wanted to correct Ms. Hofmeyer. Thank you, Chair. Remember what happened is when these documents were given to us as legal representatives of Ms. Memela, we were not told that the Commission is going to seek to re-examine. We only came to know that there's going to be a re-examination on the 28th of September. Thank you. So consequently, we did not have 2 weeks. We actually had from the 28th of September until now.
But why would it make a difference whether you were told there would be a request to question her again? Because if evidence was led that seemed to contradict what Ms. Memela may have said, then you would want to see how you could challenge that evidence.
Thank you, Chair, because you are using the word. How do we want to challenge the evidence? We were going to challenge the evidence as we are going to challenge it now in re-examination, not by invoking another expert witness, but by a different means. We are going to show them when we come in here. She is now being re-examined or cross-examined on that expert. That was not part of our strategy. And it is for that reason, Chair, why we said we wanted to go first because we would have covered these issues. Thank you, Chair.
Let's continue, Ms. Mayor. Ms. Mbanjwa, just remember that in terms of the regulations, re-examination is to clarify and clarify evidence that has been led. So the leading of evidence which had not yet been dealt with Ms. Memela might have had challenges. But let's continue. You will re-examine at some stage when the time comes.
Thank you, Chair.
Yes.
Maybe, Chair, now there's going to be another procedural issue. Sorry that I'm coming in. Because the procedural question is, there is now this evidence of Mr. Nzeku that has been put before the Commission. She is now examined on that evidence. And now the question is, must we again apply afresh to re-examine on that evidence of Nzeku? We tried to read and understand the rules of the Commission, but we couldn't deal with this very fine balance.
No, Ms. Mbanjwa, I'll let you re-examine on all the evidence that has been led. The only limitation is the time that we talked about. Ms. Hofmeyer.
Thank you, Chair. I'd just like for the record to correct a few errors in relation to dates that my learned friend referenced. It was on the 14th of September that Ms. Memela was provided with these various affidavits from Mr. Nzeku's evidence. That's because that was preceded by the invitation to Ms. Memela to provide on affidavit her response to Mr. Nzeku. It was not on the 28th of September that Ms. Memela was alerted to the fact that we would request an opportunity to question. That was the 23rd of September. So just to get the chronology right,
Yeah, let me
there's
also add.
first an invitation.
Hang on, Ms. Memela.
There's first an invitation to provide an affidavit, in response to which there's a request for a whole host of documents. Those included the affidavit of Ms. Buckley. Those were then provided on the 14th of September, and then when no affidavit had been produced by a week later, the 23rd of September, Ms. Memela was alerted to the fact that the request would be made to question her. So that's the chronology in relation to the exchange of information. I understand Ms. Mbanjwa to say it had not been their strategy to attack the expert evidence. They are going to deal with it in some other way in relation to the questioning. So we'll leave it at that if we may, Chair. Thank you.
Yeah. You still want to say something?
Yeah, I just need to add something, give clarity, Chair, to you. Remember, just to correct Ms. Hofmeyer, the documentation that was sent to my lawyer was requested by us. So it's not the commission that decided, okay, you see, we think this is fair.
Yes,
that she
but if
gets
you
this.
got the documentation, why does it matter whether it was because you requested?
No,
or-
but Ms. Hofmeyer is saying it as if we were given so that we can prepare. We had to ask for them based on,
Yeah.
on what she was putting to
Ms. Hofmeyer, please continue.
Thank you. In respect of Mr. Nzeku's concession that the sale agreement was not entered into in 2015, but was entered into 2019, do you have any other basis on which to challenge his concession than the two that we've traversed? We traversed the problems you had with the handwriting expert and the challenge that you had with the commission having focused on the Holani family as opposed to the Manzi family. Are there any other grounds?
The basis for this, Chair, is that, remember when I was giving my testimony, I said there are documentation that were made in terms of the sale of land. And I remember the documents were there as back as between 2015 and 2016. You know why I remember this? Is because Mr. Nzeku insisted during those years, like before he paid the money, that since there is no title deed, he needed some sort of a documentation that assures him, that will satisfy him that, okay, when he starts with whatever that he wants to do with the land, he will have a documentation. And I remember he insisted, and he was told that, no, there are no documents in the rural areas. And then he said, no, but I need something signed that I will hold on to. You know, so I think then my mom gave it to me in between 2015 and 2016. I know that in 2015 she was here for her eye operation. And then she went home. And then I think I went home as well. And I came back with the affidavit and gave it to Mr. Nzeku. And then the deed of sale followed after that. So that's why I'm saying, for me, I do understand, because remember, Chair, first of all,
Hang on, I don't want us to
you don't understand?
Oh,
you don't want me
have
to?
long
Okay.
stories on simple questions. The
Yeah,
question was,
yeah.
in the light of Mr. Nzeku's concession, that the agreement was only signed in 2019 by him,
Miss-
do you have any basis for suggesting that the agreement was done in 2015, other than the fact that you have challenged the issue of the conclusion of the handwriting expert, and you have challenged the issue of why the investigators went to certain people and not to other people?
Yes, I'm still challenging that.
Well, so you
I said the basis is that
you-
I know that the documents were done during that time.
So-
I'm not sure if when Mr. Nzeku was talking about signing, and I remember the question again was put to him based on the evidence, expert evidence that he said he has not seen. And
So you maintain that the agreement was signed by Mr. Nzeku in 2015, not 2019?
I'm not talking on behalf of Mr. Nzegu. I'm talking.
No, in terms of what you know.
No,
What
I'm
is,
saying
what,
I'm not.
what is it that you know in terms
Remember,
of
Chair,
when he signed?
Mr. Nzegu could testify on his behalf. For
Yes,
me,
but
I'm
he
saying
testified about a transaction that involves you and your mother.
the transaction that involves my mother.
Yes, but you,
Yes,
you
the
were going to
documents were
benefit
there.
from it.
The documents were there, Chair, between 2015 and 2016, and these documents were made to satisfy Mr. Nzegu that the land is there and my mom owns the land and therefore he can take over when
So-
he's ready to do so.
So are you saying?
So I'm saying from my mother's side, Chair.
Yeah, but do you know
document-
when Mr. Nzegu signed
Sorry?
the sale? Do you know when it was that Mr. Nzegu signed the agreement?
No, I don't remember then.
You don't know.
Yes, but I know that
He has said it was 2019. Do you accept that?
he responded to the question that was put to him.
Yes,
Yes.
or whether he responded to a question or whether he just told me without being asked, but he said it was 2019 when he signed.
Sir,
My
but
question to you is, do you accept that evidence as of his that he only signed the agreement in 2019?
Chair, I'm not in the right position to accept or deny. I'm not in the right position to accept because I remember his lawyer even stood up and challenged the issue of the year because he said it will be based on speculation.
So-
And he was forced to actually answer and he said, based on whatever expert then and whatever then, I guess then maybe it was signed in 2019.
So-
Even when he's responding to that 2019, he was still not sure.
So you don't take issue with his evidence that he signed the agreement in 2019? Or do you?
Chair, okay, can
Or you don't know? I'm just trying to establish where
No,
you
but
stand.
the problem, Chair, of questioning is that when you say I don't take issue and stuff, the fact remains that there was the deed of sale.
Sorry?
That the issue, the fact of the matter is like there was a deed of sale. From my mother's side, it had already been there between 2015 and 2016. The
Yes.
affidavit of my mom was given to Mr. Nzegu between 2015 and 2016.
If it is true that Mr. Nzegu signed in 2019, then there could not have been a sale before he signed, isn't it?
No, there could have been a sale.
Yeah.
There could have been a sale.
You say there could have
There
been,
could have been a sale before he signed.
and an agreement, and yet without his signature,
Yes, there could have been a sale.
with only one party having signed.
Yes, Chair. Remember, we explained this, but you said we must not take long to explain.
Yes.
And I said, in the villages, we don't sign or exchange deed of sale and whatever. But like, these documents
Ms.
were
Hafmeyer,
done because
please continue.
Thank you. I understand you to dispute Mr. Nzeku's concession that the affidavit was forged because you say you know your mother attested to it in September of 2015. Is that correct?
I said my mother gave me the affidavit already signed
Right.
to give it to Mr. Nzegu because Mr. Nzegu was insisting that since there is no
Yes.
title deed, I needed documentation.
Right. And that's despite the fact that that affidavit bears the date of 2019. Is that correct? You still say you got it in 2015.
The affidavit, Chair, bears the date of 2015 where it was signed and commissioned. The date of 2019 was where you see an error issue where you actually say, because I remember Mr. Nzegu even asked me, what about this? And I said, but this part is not filled in. So it does not make this affidavit invalid at all. And my understanding, Chair, also, because these documents were made for him, it should have been him who went and said, okay, I think you guys are Nyandro Balana, so let me go and get an expert. Because it was to satisfy him. So
Ms.
when
Hafmeyer.
Mr. Hafmeyer is talking about forgery, was the affidavit forged to rob Mr. Nzegu? Forged for
Ms.
who?
Hafmeyer, please
Yes.
continue.
Thank you. And then just again, you say you dispute Mr. Nzeku's version because you know the sale was concluded in 2015. Is that correct?
I know the land was sold in 2015.
Yes.
yes.
The sale agreement, was it concluded in 2015, Ms. Mamela?
The sale agreement was already there in 2015, I think, yes.
It was?
Yeah.
Right. And it referred to a dispute resolution provision that anticipated the Legal Practice Council
Yeah.
resolving who would be appointed at a time when it didn't exist.
Yeah.
Correct?
It talks about the legal counsel that didn't exist,
Yes.
but the Legal Practice Council Act was already promulgated in 2014.
Yes,
So
Ms.
as
Memela,
much
it was.
Thank you. As much as I was not the drafter of that document, we cannot say, okay, all the contract, Chair, should be exhaustive. A
But
person has
Ms.
no right.
Memela,
okay.
Ms. Memela, is the position not that in 2015, there was no legal practice council that was operational, that had been established?
Yes, but remember, so when we're talking about dispute resolution, we're talking about something that will happen later, right?
Yes, but,
exactly.
but there was no legal practice council in operation at the time,
But
in
there was
2015, isn't it?
There was a Legal Counsel Act that
Ms.
was promulgated
Memela,
in 2014.
listen to me carefully.
Yeah.
You agree that in 2015, there was no legal practice council in operation.
Yes, the council.
Actually, there was no legal practice council at all, because if
started
it was
in
still a
2018.
bill and not an act, there was no such structure, isn't it?
Yes,
Was it not still a bill in 2015?
so
No, it was enacted in 2015, but it
Yeah.
had a series of sections that would be brought into operation.
operation,
And the
yes.
establishment of the council occurred in October of 2018.
Yes, but there was simply no legal practice council in operation in 2015.
Yes, I agree. There was no Legal Practice Council in
Yes.
20 years, but
So
the Act
now-
was already there.
How could people in 2015, when they look for somebody who would resolve their disputes, say that, choose a structure that is not in operation,
But if you
when there were structures in operation that they could choose?
Chair, if you saw that under dispute resolution, it doesn't just jump to the Legal Practice Council. It starts, okay, the parties will go there first, and then if this fails, they go there, and then if they, you see now I'm talking on behalf of the drafter, that I don't know, but like I'm just saying there were processes that were listed there. Chair, can I give an example? Remember the Companies Act was promulgated in 2008, right? But it was passed in 2011. But I can tell you now, most lawyers in the commercial sector, they were already referring to some of the sections of the Companies Act as far back as 2009 and 2010. So I'm just saying, I'm not defending because I was not a drafter, but if I was a drafter, I would defend it by saying that there's nothing that is stopping you from referring to something that you know that is going to happen in the future.
Ms. Hofmeyer?
Thank you. I'd then like to go to why that 2.5 million was paid, because you earlier said it's a sale agreement between your mother and Mr. Nzeku, correct? But it referred to you benefiting from it, didn't it?
It referred
To you benefiting from the money that would be paid pursuant to the agreement, didn't it?
Yes, remember during my during my testimony in Feb, Chair, I gave the testimony that the plan was for me to buy the land in Coveridge in East London. So the plan was for my mother to help me buy that land, which was 2.8, the one that was in East London. Then in 2016 changed my mind. Because the land in East London, it took longer for proclamation to come in. And that's when we cancelled and said, okay, let me use the money for the deposit. And then my mom gave me the 1.5, not the 2.5 that Ms. Hofmeyer keeps on referring to. The deposit for my house in Bedfordview was for 1.5, and then the remainder, it was the bond.
Oh, Ms. Memela,
Yeah.
is your evidence before this commission today that you did not utilize the full 2.5 million rand that was paid by JM Aviation to Mbanjwa Incorporated?
To buy?
You've just said that I keep referring to 2.5 million, when
yeah.
in fact only 1.5 million was...
Yes, I'm saying, Chair, the way you keep on saying it, Ms. Hofmeyer, is that it's as if the whole 2.5 went to the house as a deposit, and it was to benefit me to buy my house in Bedfordview. She no longer wants to refer to the land in Coveridge, that was the reason why my mom was going to help me to buy that land in Coveridge. The Bedfordview issue came into account only later in 2016.
Ms. Memela, I do want to go to Cove Ridge very, very pertinently, but I need to get your evidence on this correct.
Okay.
Do you accept that the 2.5 million that JM Aviation paid to Mbanjwa Incorporated on the 6th of May 2016 was used by you, the whole 2.5 million?
Not the whole 2.5 million.
How much was used by you?
The deposit for 1.5 Chair. And I remember some, it was used to renovate my mom's home and help her, like, because she had a heart problem, and then she was taken to specialists and all that. So there was a lot that it was used for.
So you don't remember being paid more than 800,000 rand after the transaction had gone through on the home
Yes.
into your bank account, which you then used?
Yes, I'm saying, remember, you even asked Chair during my last examination that, okay, why couldn't this money go directly to your mom? And I said, no, it went to the lawyers, then the other came to me. So when I say it was not used solely for me, it was used for my mom's health, it was used to renovate my mom's home as well.
How much was used for your mom?
Then I don't remember the exact amount, but I renovated the whole house.
So you accept that you received 1.5 million to pay the deposit on the house,
Yeah.
and you received after the transaction, I think it was 886,000.
Yes, yeah.
My colleagues will add that up for me, but that's very close to 2.5 million. We'll do the calculation now. So there would have been a little bit of the 2.5 million that wasn't used by you directly. Is that correct?
No, Chair, then Ms. Hofmeyer is talking about the 1.5, right? Plus the 800 that was left from the money that went
Yeah,
to
that's
the
2.3.
that went to the lawyers, yes. So then she's taking the 200, thinking that, okay, that's the one that was used for my mom. I'm saying, like, whatever that I did for my mom was coming from that 800,000.
Right.
That came to me, yes.
So when we go to your bank statements, you'll be able to show me where you used it for your mother.
Okay, so how am I going, like, must I show that I bought tiles in 2016 and
Yes.
do that and stuff?
Yes,
From
because we have
from
your
the
bank statements from the moment the 886,000 came into your account till it was depleted. You'll be able to show me there where you paid for something for your mother, will you?
But
Ms. Mbanjwa?
But Chair, really, are you telling me that now this thing is going to be extended to us now going to draw the bank statement? Isn't the issue here being simple, the receipt of the 2.5 million which has not been denied?
Ms. Mbanjwa, Ms. Hofmeyer wants to know exactly how much of the 2.5 million was used for Ms. Memela's benefit, how much of it was not used for her benefit.
What is the relevance, Chair? What is the relevance of
Ms.
that?
Mbanjwa, I'm speaking at the moment.
Apology.
Okay. Ms. Hofmeyer wants to establish how much of the 2.5 million was used for the benefit of Ms. Memela, how much of it was not used for her benefit, because she has said that it was not the whole amount of 2.5 that was used for her
Yes.
benefit. And I would like to know that as well, how much of it was used for her, how much of it was not used for her.
And the question, Chair, is the relevance. Because the issue here is, it has not been contested that she received the money.
Please sit down,
so
Ms.
what is
Mbanjwa.
the relevance?
Please sit down.
Thank
Carry
you.
on, Ms. Hofmeyer.
Thank you. So just to return, if we looked at your bank statements after you received the 886,000 from the transferring attorneys on the Bedford View house, would we be able to see what you paid to benefit your mother?
the problem now, Shay, is that I can't really give a direct answer there to say, okay, you will see that this was bought, this paid a specialist, this went to there, and this went to that. You understand? Because remember, other than this deposit, and other than the money for the sale of the land, I've always been a breadwinner at home. And I'm not sure how then I'm expected, because during that time there was no expectation that one day I will come to the commission and explain that, okay, out of this, how much then, since your mom sold this, how much was it spent to her
But,
and stuff. But the bank statement, Chef, sorry, the bank statement, I doubt that it will say, okay, you swiped for the tiles, you swiped for cement, you
But,
swiped for, yes.
Ms. Memela, if the 2.5 million
Yeah,
was actually for your mom, because my understanding from your evidence last time was that your mom was giving you a loan
no, a donation, not a loan.
or a donation. Yeah,
Yes, sir.
okay, I may have misunderstood. Okay. Now, and that she was doing so to enable you to
buy the land.
acquire property.
Yes.
Now, if all you needed for purposes of acquiring the property was 1.5, why didn't you give her the balance and then she would decide what she does with it? Why did you decide to be the one to buy whatever to renovate the house rather than give the money to her? Because it was her money.
It was her money, Chair, but remember also in her affidavit, she did say that she was going to help me to buy, I think it's the deed of sale, to help me buy the land, right? So I don't know if the Chair was expecting me to take the money and then give it back to her. And the
I
remainder-
was thinking if this was her money, 2.5, because Mr. Nzeko bought land from her,
Yes,
and she wanted to assist you to acquire property, and you didn't need the whole 2.5, you needed 1.5. I expected that she would give you 1.5
remember, Chair,
and keep the balance, and if, for whatever practical reasons, the 2.5 came to you, once you had deducted the 1.5, you would then say, Mom, here is the balance, I've taken the money that I need for the house.
Chair, remember the reason why she was selling the land was to help me buy the land in coverage, which was worth 2.8. Right.
Which was worth?
2.8 in coverage. And then, as I said, then I changed in 2016. I decided, okay, I'm going to use this money to pay the deposit of 1.5 that was needed by the bank for the Bedford View. So all I was saying to Ms. Hofmeyer is that when she says, okay, that 2.5 was put there, it's as if I was saying, it's as if the whole 2.5 was put towards the property at Bedford View. And it was actually that decision. It's like she no longer refers to coverage, but she says, okay, because she has already asked me about that the last time.
No, I
She
said
just
I was
wants
going to come to it.
focus on Bedford View.
So
I'm saying, from the bank statement, I don't know if I will ask my lawyer. I don't know if I should say I will then go to the bank but I can't promise that, okay, the bank statement will say, okay, this is what you swiped for. Then it will explain what did I buy, what did I do, like what is it that I buy.
but you are
Bought
saying
for my
that
mother.
the whole 2.5 million rand, your mom gave it to you as a donation.
She was helping me with the deposit, 1.5.
Yeah, was
She
it a
helped me with the
donation
deposit.
or was it a loan?
It was a donation. It was not a loan.
The donation being 2.5 or the donation being 1.5?
Now that I had a change of heart to buy the Bedford View house, it was 1.5.
But when she
Then
gave
after-
it to you
Yes.
initially, was she giving you a donation of 2.5?
Yes, she was going to give me the donation of 2.5 for the coverage house, for
Yeah.
the coverage land, yes.
Yeah, and she gave you that.
Yeah, she was going to give me that, but remember it was cancelled, the
And
coverage.
then later on, you decided to use only 1.5. But the
I did-
donation to you was the entire 2.5 million.
Yeah, for coverage, because it was 2.8,
Yeah.
yes.
And just back to the chair's question, at no point when you received, I made an error earlier, it wasn't 886,000, it was 862,376 rand and 75 cents after the sale of the Bedford View house. You didn't feel that you should go back to your mother and say, let me give you back 826,000, which I didn't need to use because I ended up getting the Bedford View house and not the coverage transaction. You didn't do that.
So you're saying I did not help my mother out of this 800?
I'm saying you didn't go back to her and say, I've only used 1.5, let me give you the remainder.
Okay, Chair, I'm trying to understand that you're expecting me to go to...
No, I'm asking whether you did. Did you go to her and say, I've only used 1.5, let me give you back the 862,000 that remains? You didn't do that.
No, I did not go back and say, okay, let me give you the remainder. I just continued paying for certain things that she needed, like as I always did without 2.5 or 1.5 before.
Do you recall that you invested 250,000 of it?
Yes.
Yes. We'll go to some of the other things you did with the money in a moment. But let's go to coverage, because it is an important part of this, Chair. And it's really the last part that I would like to focus on for the afternoon. Because, Ms. Memela, in fairness to you, we had evidence with Mr. Nzeku, in which in the end he conceded that the sale agreement was a fraud. You heard his evidence, is that correct?
That's what he said.
Yes. I'm going to put it to you this afternoon that the coverage transaction was also a fraud.
I don't agree.
You don't agree?
Yeah.
Let me take you through why I put that to you.
Okay.
Right. So, you entered into the coverage agreement, is that correct? When
Yes.
was that?
I think it was 2015.
Yes.
Early 2015.
April 2015.
Yeah.
Let's go to it. You'll find it in Exhibit DD25A at page 370.
Page?
370. Is that the coverage deed of sale?
Yes, that's the one.
That's the one we looked at briefly in your evidence previously.
Yeah.
You were buying this property from Slipknot Investments, is that correct?
That's correct.
And Ms. Yake Kwinana was a director of Slipknot Investments at the time, is that correct?
Yes, I agreed to that as well.
And you signed the agreement with her, is that right?
That's right.
And it appears as though this agreement was signed on the 21st of April 2015. You'll find that at page 373, is that right?
That's right.
Do you confirm that you did sign it on that day?
Yes. Let me check quickly. Yes.
Yes. Your evidence previously was that you'd signed this at the offices of Ms. Mbanjwa, is that correct?
That's correct.
Yes, because Ms. Mbanjwa at the time was Ms. Kwinana's lawyer, is that
Yes,
correct?
that's correct.
And Ms. Mbanjwa put this agreement together, is that correct?
Yes.
Right. Now, do you remember what had happened 2 months before that, in February of 2015, in relation to property acquisitions that you were entering into?
Property acquisition.
Yes.
Do I remember?
February 2015, did you purchase any property then?
February 2015. No, I don't remember.
Do you remember putting in an offer on a property in Raceview?
Raceview? Where's Raceview?
I'm not sure where Raceview is. Your offer to purchase just says Raceview.
Okay, where is the offer to purchase?
Let me ask first, do you remember putting in an offer to buy a property in Raceview in
2015.
February 2015?
I don't remember.
You don't remember. Okay, let's go to it. You'll find it in DD 25C.
The page?
The page is 1123. You'll see it's not an excellent copy, Chair. This is the best version of the copy that the Commission has been able to obtain. The parties, you'll see they are, sorry, it's a letter Gertruda and Benjamin John, I can't even quite read the name of the sellers. Maybe it'll be clearer later. Trutter. And you and your husband are the purchasers, are you not?
Yeah, I see the thing, yes.
You see that? It was
I'm
for...
sorry, where does that appear?
If you see just a little bit down, it's about the 5th line, Chair. The undersigned, it says Nontsasa Memela, Vumile Mumela of 6 Yonker Crescent, Elands Park, Johannesburg, 2197. Do you see that, Chair?
Is that at page 1123?
Yes, 1123. You'll see there's a first line that says to. Do you have that?
Yes.
Then there's a line that starts of.
Yeah.
And then 2 lines further down it says, I think it's supposed to be we, the undersigned. And then you'll see written in there is Nontsasa Memela, Vumile Mumela. Do you see that?
Oh, okay. Yeah. Yes, now I see that.
They
Yeah.
are the purchasers.
Before Yonke Crescent.
Exactly, Chair.
Okay.
So can you confirm at the time you were living in Yonker Crescent, Elands Park,
Yeah.
Ms. Memela? Right. And you put in this offer to purchase a property described as freehold stand 6 in Township Raceview. Do you see that?
Yeah.
Yes. And it's an offer to purchase for 1.4 million. Do you see that?
Yeah.
Does this jog your memory?
Yeah, it does remind me.
Right. So you were putting in an offer to purchase in February of 2015 with your husband to buy a property in Raceview for 1.4 million. Is that correct?
That's correct.
So that's 2 months before you conclude the slip-knot agreement with Ms. Kwinana. Correct?
Yeah.
Right. What happened to this property?
It did not go through.
Why not?
I explained, remember, that in 2015 there was difficulty in terms of the bank. They were not really approving 100%, or sometimes they would decline based on reasons like put by them. So I kept on trying and kept on trying. Yeah.
So you'd applied for a bond for this
Yeah.
property, is that correct?
Yes.
And it was declined by the bank, is that correct? So they declined a bond for 1.4 million, is that
Yeah.
correct?
Yes.
Yes, and they did that the next month, in March of 2015. Do you recall that?
I see the letter here.
Yes.
Yeah.
So you put an offer to purchase in February 2015. The bank won't give you a bond of 1.4 million in March of 2015, correct?
Yeah.
And then in April of 2015, you commit yourself to 2.8 million that you're going to pay to Ms. Kwinana's company, Slipknot.
Yes.
Where
because
were you
there
going to get that 2.8 million?
Remember, the land that was sold in Mpindweni was going to help me with that.
No,
So
the
of
land
course-
sold in Mpindweni happens later in 2015.
No. Remember, my mom was going to help me, as I told you this, my mom was going to help me with the purchase of the land in coverage, right? Which took longer to be finalized because the proclamation was not in place by then. So the 2.5 was going to go to that land, and we're going to only go to the bank just for 300,000 rand. So like that was the understanding back then.
No, you weren't going to go to the bank for 300,000. I think you're getting the property transactions confused. Remember, in April 2015, you agree with Ms. Kwinana that you're going to pay her outright 2.8 million rand. There was no deposit, nothing. There was
Yes.
no bond either, correct?
There is no bond, yes.
Yes.
Exactly.
And you entered into that agreement with Ms. Kwinana when the month before you didn't have 1.4 million and the bank wouldn't give you a bond for 1.4 million.
Yes.
Is that correct?
But I knew that my mom was going to sell the land.
How
so
did you
that
know she was going to sell the land?
We spoke.
But she didn't have a
spoke.
purchaser at the time, did she?
She?
Didn't have a purchaser.
No, of course she didn't, but she was looking for the purchaser.
Ms.
She was already
Memela,
looking.
Ms. Memela, are you saying that when the previous month, you didn't have 1.4 and the bank declined your bond application, you made an offer for a property that would require 2.8 million? That's about what? That's about that's about more than an extra million.
Yes.
Is that right? More than an
That's-
extra million.
Yes,
Double,
that's correct.
actually. It's double.
Yeah,
2
double.
yeah.
Double. Simply because you were hoping that your mother would get somebody to buy the property.
She was already
You make a
looking.
firm offer on the basis of that hope when there was no purchaser.
There was no purchaser yet, but she was already looking for the purchaser, Chair.
Yes, but
Yes.
Ms. Memela, you can't make an offer, a serious offer, on the basis of money that you don't have,
You
and
can-
you have no guarantee you are going to have.
You can make an offer, Chair, if you know that you are hoping
But
to get.
in the offer, did you say conditional upon my mother being able to sell the
No,
property?
no, there was no such condition in the offer. And Ms. Hofmeyer asked about this during my testimony. And she went as far as saying there was no provision that identifies.
Just
maybe
hang on
the-
one second. Ms. Mbandwa, what's the story?
And this document is on page 371, that is the coverage sale. She says that this was going to be a cash because there's no mention of a bond. There's nothing in that document saying that that was going to be a cash sale. I'm just correcting that for the record.
Just to be
It
clear, I
is
didn't
your
say
own
cash, I said it
assumption.
was an outright
Yes.
offer to purchase for 2.8 million that made no reference to a deposit or a bond.
Yeah.
Thank you.
Yes, but what I would beg, Chair, I know that there is a rush to finalize, but what I would beg for is, if there is a document, because that is just standard law, if there is a written document, that document is the evidence of what it purports to be. There is no basis for Ms. Hofmeyer or even myself to go further and say this is what this document meant. If that document doesn't say it's a cash
Please
price,
sit
it
down,
means-
Ms. Mbandwa. Please sit down. Let's have some progress, please.
Okay.
Okay. Ms. Hofmeyer, please continue.
Thank you, Chair. You were probing the circumstances
Oh,
in
yes.
which Ms. Memela
Yes.
could commit to 2.8 million in a property transaction with Ms. Kwinana when the
Yes.
previous month she didn't have
Yes,
1.4
you were
million.
still answering that
I
question.
was still answering
Yeah.
that, Chair. I'm surprised that this offer to purchase is here, but others are not here. Just to prove, Chair, how many times I kept on trying.
But
you know.
Ms. Memela, if you make an offer to somebody who is selling a property to say you are going to buy the property
Yes,
for a certain amount, and you don't indicate in the agreement that that is dependent upon some other transaction, you are creating the impression to the seller that you have got the money.
no,
You are.
well,
Otherwise, why should he or she take your offer seriously?
Chair, I think I explained this last time, but I will try and be as short as possible. That land in coverage still had certain processes to follow. I knew that I was informed that it was going to take longer to be proclaimed or whatever processes that need to be followed. And I can tell you now, even to this date, it has not. So not putting the condition or maybe the provision that says, okay, I'm going to go to the bank and get the bond, or maybe I'm going to get the money from here to pay. It was neither here nor there because we knew that it was going to take longer anyway.
But
That's why the
Miss-
seller actually allowed me to cancel when it took longer and commit to something else.
But Ms. Memela, are you saying to me it is in order for somebody to offer somebody who is selling a house to make an offer to buy the house for an amount that they can't afford as at that time, and they are making that offer on the basis that they might get the money if some other transaction happens.
Okay,
without disclosing that that is the condition. You say that is proper.
that's proper, Chair, especially if like the buyer and the seller have the same understanding. And Chair, remember the fact that this application was declined in March, because this process was going to take longer, the proclamation and all. So remember, the bank gives you 6 months to actually go back and approach them for the bond. So there was that also possibility of option to approach the bank maybe after 6 months also. So the fact that it's not there, that okay, we'll get the bond,
Ms.
does not
Mayor,
mean it's
continue.
not there.
Thank you, Chair. I just want to ask about this slipknot agreement, one other factor in it. Did you discuss it with your husband?
Can we go back there?
The slipknot agreement, it's at page 371 in Exhibit DD 25A.
371?
Yes, I think you might be in the wrong file. You need to be in DD 25A, Ms. Memela.
Okay. I get it. So you're asking me?
I'm asking you whether you discussed this agreement with your husband.
I didn't.
You didn't.
Yeah.
What is your marital regime?
Now, Chair, that is a personal issue.
What marital regime you're married under?
That is personal. That is a personal issue now.
But isn't the position, Ms. Memela, that depending on your marital regime, you may not make a valid offer without the consent of the other?
No, Chair, there are
Partner.
lots of things that I bought without my husband's
Sorry?
consent. There are lots of things that I had purchased without my husband's consent, including the car
Well.
and stuff, yes.
But the Matrimonial Property Act says you can't buy property without the consent of your husband if you're married in community of property, doesn't
Also,
it?
the car is a property, but I bought it on my
No.
own.
Transactions governed by the Alienation of Land Act. Ms. Memela, let's just get the facts. Are you married in community of property with your husband?
I'm married according to customary law.
Chair, my apologies. I'm not aware of this provision. Before this version is put to the witness, I want to get the version that says you cannot sign an offer to purchase property if you are married in community of property without the other party signing.
Section 15(2)(g) of the Matrimonial Property Act. I'll come back to it in a moment.
It's very logical, Ms. Mbandra. Can't be married to you in community of property and you go and get involved in huge debts without my consent because it will affect me.
But, Chair, I will address this as a legal issue. The conclusion that is reached here is incorrect. And the witness is a legal question. I will address this in re-examination. The legal
Continue,
ramifications
Mr.
that-
Hofmeyr.
Because it does not make the offer invalid.
You will deal with it
Yes, I
later
will deal
on,
with it.
Ms.
Indeed,
Mbandra.
indeed, Chair.
So is your evidence that you're not married in community of property to your husband?
I am married in community of property because all customary marriages fall under community of property.
And so that's why when you had to give a FICA declaration to the transferring attorneys on your Bedford View house, you indicated that you were married in community of property, correct?
Yes, we're buying that house together, remember?
Yes, you have to buy it together by law. That's what's unusual about the slipknot investment property
does not make it
acquisition.
invalid.
Because you can't purchase that property legally, Ms. Memela, without your husband's consent. Do you accept that?
We'll argue that later.
No, what's your understanding of the law? Can you enter into a property transaction governed by the Alienation of Land Act without your husband's consent to whom you are married in community of property?
Chair, okay, I'm not going to entertain that question right now because
Is your
it's a
position
It's a question that is looking into disregarding
Let's
an
talk
agreement
about
that
your
was entered
understanding.
into.
Let us talk about your understanding. Is your understanding that you can?
I have bought a property with my husband.
Mhm.
The
With his
Bedford
consent.
one, exactly.
Yeah.
That we signed together.
Yes.
And then we signed other offered purchases together. But there are certain offered purchases that were signed by me alone.
But it's the, sorry, Chair. The question is your understanding of the law, right?
No.
Is it your understanding of the law that you could enter into the Slipknot investment to buy a property for 2.8 million without your husband's consent?
Yes, remember the contract can be amended anytime, Mr. Mayor.
Ms. Memela, we went
Okay.
through this last time,
Okay.
but we
Chair,
don't
I
need to
don't
go
want to
further.
be impertinent. I have a copy of the Alienation of Land Act here. There is nothing that talks even about the community being married in community of property. That's why I said, can Ms. Hofmeyer please, because she is saying that, can you sign an offer to purchase a loan if you are married in community of property?
You will re-examine
Yes,
her.
an offer. But this thing is going on record, Your Worship, and I want to be
No,
referred to the
Miss
relevant section of
Miss
the
Mbanjwa, whatever answer the witness gives, when you get a chance, you can re-examine her on that to get to give a
in that
different
case,
picture.
Chair, may I humbly ask that the witness must not be badgered with legal questions if those legal questions were not being referred to, because she is obliged to answer. And I'm also searching for the section. I cannot find the section. Otherwise, it is unfair cross-examination.
I think Ms. Hofmeyer has passed, has asked
Yeah.
whatever she wanted to ask on the
Yes,
the
but can we
issue.
put it on record, Your Worship, that this reference to the Alienation of Land Act is incorrect because there is no such provision in the Alienation of Land Act.
That's
Chair
fine.
didn't refer
When
to
you
the Alienation
re-examine,
of
you
Land
can raise
Act.
that. Yes.
We have put it on record. We are
Ms.
fine. We are
Hofmeyer,
fine, Chair. Thank you, Chair.
continue.
Thank you. So your evidence is you didn't discuss the Slipknot transaction with your husband, is that correct?
No, I didn't.
But you say in your evidence that you concluded it in April of 2015 and you signed with Ms. Kwinana at Ms. Mbanjwa's offices, is that correct?
That's correct.
And you were the purchaser under this agreement, is that
Yes,
right?
that's correct.
Do you know what the Financial Intelligence Center Act requires of attorneys who are appointed as the conveyancers under agreements of this nature in terms of the information they have to get from the parties to the agreement?
You tell me?
No, do you know the
No, I
requirements?
don't. I'm saying tell me.
You don't know. There are certain details of the client that need to be obtained. It's information like what's your property regime, where do you live, you need to provide a proof of residence, etc. Are you aware of that at all?
Oh, you're talking about the
The FICA form, yeah,
yes.
that's the Financial Intelligence Center
Yes.
Act.
No, I do.
You're aware of that. Are you aware of Ms. Mbanjwa asking you for that when you concluded the sale agreement at her offices in April of 2015?
No, I don't remember.
Do you remember ever giving her a FICA document containing your information?
No, I don't remember. But Chair, all I'm saying is that the deed of sales, they differ from one to the other. Sometimes some lawyers, not just Ms. Mbanjwa, some lawyers would ask for those. I remember it's just the forms at the end of the agreement where people fill in the details. But there is, I'm not sure if Ms. Hoffman is trying to say maybe if those are not provided, it makes the deed of sale invalid.
No,
Is
I'm
that
not
what you-
suggesting that at all.
Oh,
I'm
okay.
asking about your knowledge of the FICA requirement that an attorney that's regulated by FICA must get information related to the client when she's the conveyancing attorney for a transaction. And you've said you don't know about those requirements.
Yes, and you told me, so I've just asked if it makes it invalid, and you said, no, that's not what you're suggesting.
No.
Thanks.
So you don't recall giving Ms. Mbanjwa a FICA client take-on sheet
No, I
in
don't
relation to the transactions. Let me take you to the one that Ms. Mbanjwa provided to the Commission, which contains your information. You'll find it in Exhibit DD25C.
Did you?
Chair, just a point of correction. I work as an attorney in an office with many
Ms. Mbanjwa, you can correct during re-examination.
Thank you,
I want us to make progress. You
Thank
keep
you,
on
Chair.
standing up all the time. You are hampering progress.
Can you give me the page?
Right, it's towards the end. You'll find it starting at page 1129.
Is that under 25A?
25C, Chair. Apologies, we have to go back to C.
And what's the page?
1129. It's right towards the end. 1129.
which bundle, Ms. Hoffman?
25C. And so what you see at page 1129, Ms. Memela, is the
see.
response from Ms. Mbanjwa to a subpoena, well, a summons under the auspices of the commission to which she was responding. Do you see that?
I see that.
And she indicates what documents are attached.
Okay.
There's the deed of sale, which is the slip-knot investment agreement that we've been looking at. And then at page 1135, there's the client take-on sheet in relation to this. Do you see that?
Yeah.
Is that not a document that you recall?
Which page are we going to?
1135.
1135. Okay. They are my details here.
Yes, you said you didn't recall giving Ms. Mbanjwa a client take-on form. Do you now remember it?
But Chair, saying I do not recall does not mean you saying you deny it. I just said I don't recall.
Ms. Hofmeyer knows that. She doesn't mean that.
Okay.
Do you now remember
Now I
it?
remember.
Did you fill it out? Is this your handwriting?
No, this is not my handwriting.
And at the bottom there seems to be a signature. Is that your signature?
No.
So have you seen this document before?
Chair, I wouldn't remember because it's something that happened in 2015. Because now I can see also my ID that was applicable at that time, it was the book ID.
So you don't have a recollection of this?
Yes, but these are my details.
Right,
Yeah.
right. And you see, what's interesting about what you just said is that this was something that happened in 2015. You see, that's also what I would have thought, because you entered into the slipknot agreement in April of 2015, didn't you?
Yes, it was signed in 2015.
Yes.
Yeah, but I'm just saying the ID that I was using back 2015, 2016, I think I started having only the card in 2017 or something. Yeah.
You see, the FICA requirements are that the conveyancing attorney who's identified in the property agreement must get this information from the client. So they do what is called client take-on sheets. Do you see that at page
It's written
1135?
there.
Yes. This client take-on sheet was concluded in 2016, though, not in 2015 when you entered into the slipknot agreement.
Yes, but,
Was it?
Yeah, but is there something in that the FICA that you are quoting that says, okay, the personal client take-on sheet should be signed on the same date?
Well, it's when you take on the client, hence the name.
But what if the client was Ms. Yake Kunan, as you said, she's always been her client, and then I was...
No, you're the
getting
purchaser,
yeah.
so you need to get the information from both parties.
Yeah, but I'm just asking again, does the FICA act that you are referring to say it should be signed in the same day?
When you
as-
take on the client,
I understand the
and if
take-on
you were
part,
taken
which is
on as a
written here.
client,
Yeah.
because you concluded the slipknot agreement in April of 2015, you would have expected there to be a client take-on sheet in 2015, wouldn't you?
Chair, I don't know if I would remember properly, but I know that certain, I don't know if it was the Bedford View one or maybe other offer to purchase, where you will be called in, maybe later on when they want to do their filing and stuff and say, okay, you know what, we did not fill in this. So that's why you hear me asking Ms. Hofmeyer if there is any legislation that says it should be done in the same day. So sometimes it's done later or afterwards, but because what is important is the deed of sale that has been entered into. Yeah.
See, what's relevant about the date when it was done is it's done the day after JM Aviation paid the 2.5 million to Ms. Mbanjwa. It wasn't done back in April 2015 when you concluded the agreement with Ms. Kwinana, according to your evidence. Do you accept that?
We're saying it was done after?
JM Aviation paid the 2.5 million to Ms. Mbanjwa.
I don't know, when was it?
It was paid on the 5th of May 2016, and this is dated the 6th of May 2016. Do you see that?
I see that, okay.
Yes. So you don't dispute what is contained on this document?
Yes.
That it was only prepared on the 6th of May 2016 in circumstances when you'd entered into the slipknot investment in April of 2015, correct?
Correct.
Thank you. So let's just talk about what happens. You conclude the agreement in April of 2015 with Ms. Kwinana without talking to your husband about it, correct?
I'm not sure if maybe the commission now is trying to cause a dispute between myself and my husband, because I'm really I'm trying to understand. Do you understand?
I'm seeking not to create
No,
marital
exactly.
strife. I'm just wanting to get the chronology right.
Chair, not in a bad manner or anything like that. I'm not talking for other people, but I'm just saying certain things you don't discuss. You just say, okay, we're going to do that. I'm going to invest in that, and whatever. I even mentioned the last time that investment has always been my thing, especially in property. When we bought a home in 4 ways in 2007, we also bought flats in Bloemfontein for the students and stuff like. Now I'm going back to what Ms. Hofmeyer is saying, that okay, you can't buy this when you had just bought that and stuff.
Yeah, but
so,
we are
but
going
my
to-
worry now is that
we
I
are
will
going to-
get a call, or my husband, I will find my husband not talking to me because of these questions. And
Yeah.
then maybe I will be handed
Well,
divorce papers because of this kind of question. And that's not my understanding of the
the
commission,
problem
where
is that if the
and now
question-
you're causing dispute
Ms.
within the
Memela?
family. Yeah.
The problem is that we are going to waste time if you don't answer a straightforward question, and if it's relevant, it's got to be answered.
See, though, I want to put it to you. I said that I was going to deal with the slipknot investment and put to you that it was not a genuine agreement. And what I'm going through are the various indicators that I will put to you show that it was not a genuine agreement. And that's why I raised the question of the marital regime under which you were married and your husband's role. Because the other agreements that we've seen, Ms. Memela, where you purchase property,
All of them.
the ones we've seen, yes?
Oh, you
Race
just-
View, Bedford View, etc.
Yeah, I see.
It's
The
you
ones
and
that you've seen,
Mr.
yes,
Memela
thanks.
who jointly purchased the property, right? This stands out because it's the one where he doesn't join you in purchasing the property. Do you accept that?
But the purchase go through.
No, it's about whether you can validly make the offer.
Okay, we're talking
He
about the
didn't join you,
agreement.
yes, in making that offer, did he?
His signature is not there here.
Yes. And the second feature is that you didn't fill out a client take-on form at the time that you entered into that agreement, despite being at Ms. Mbanjwa's offices. The only time that was filled out for you was a whole year later, only after you got the JM Aviation money. Is that correct?
Chair, that's what I just explained, that many law firms, in fact, many conveyancers, I'm not a conveyancer, but sometimes they will call you later on to take your details and fill in that form. So I even asked Ms. Hofmeyer if there is a regulation somewhere where it says, okay, this must be signed or filled in at the same day, otherwise it makes it invalid. And she said that's not what she's suggesting.
No, it was slightly different. You were asking me whether the fact that you didn't fill it out invalidated the agreement, and I said that's not the case.
Okay.
But FICA requires the person governed by FICA to get that information from you before a transaction takes place. And we'll argue in due course, Chair, that the conclusion of that sale agreement created those obligations for the conveyancing attorney, who was Ms. Mbanjwa, and that it is relevant that no client take-on sheet was completed then. It was only completed the day after the JM Aviation money came into Ms. Mbanjwa's trust account. But let's move on then to...
With your permission, can I make just one clarification?
Sorry? You want to make what?
Just one comment.
Yeah, but why are you not reserving that comment for your re-examination?
No, it's because Ms. Hofmeyer is arguing on a wrong understanding of law.
No, you can
Sit,
deal with
please.
that later. Please sit down, Ms.
Thank
Mbanjwa.
Okay, so we've moved from April of 2015, right, when you conclude the slip-knot agreement with Ms. Kwinana, and I want to now move to February of 2016. Okay. Because in February 2016, you owe Ms. Kwinana 2.8 million in accordance with the slip-knot investments agreement. Is that correct?
I don't, Okay, I corrected this in February. I don't owe because it was not transferred to me yet. We're still waiting for the proclamation.
Where does
So-
the slip-knot agreement talk about the proclamation?
It does not talk about that, but I mean, that's what was happening. And I believe that if you need those documentation to be provided to the commission, they could be found.
What proclamation was it?
Can you explain, Ms. Major?
You're the one giving evidence. Please tell us what proclamation was required.
I said, there are processes, Chair, to put the land into.
Ms. Chair, if I could just request that Ms. Memela not seek an answer from her legal
Okay.
representative. I'd like Ms. Memela to give us the evidence about the proclamation.
No, the
What
problem
proclamation was required?
Chair, the problem is that Ms. Manjwa here is a conveyancer. Remember, I was just a buyer, not a conveyancer. So she would understand those details.
Yeah, but you can't
Better than
ask
me.
for her assistance while you are giving evidence.
Okay.
You must
What
give
did
evidence
you understand
on
the
what you know.
proclamation to be?
Okay, the proclamation will be where the land is now measured or sized or whatever the process that is done to make sure that the land is now ready to be handed over for sale or whatever.
No,
I
it
may
was
be wrong.
perfectly described in the slip-knot agreement. It was portion 11 of Farm A 925 Cove Ridge, East London. So what else had to happen? Measuring 8.5 hectares. What else had to happen?
No, okay, Chair, let me not answer something that I'm not sure of. Then my lawyer is going to cover that, and
No.
then we'll explain better.
Your lawyer, unfortunately, Ms. Mamela, can't give evidence in this commission. Only you can. You have told us that this agreement was subject to some proclamation that was
Yes.
going to happen, but you're unable to tell us what that proclamation is. Is that correct?
But remember, the proclamation part is something that is an explanation that should come from the seller. What was explained to me was that was what is going to happen, and that's why when I approached her with regard to, okay, I think now I want to buy from Bedford View, she was okay because she said this thing is taking longer than we expected.
But Ms. Mamela-
Ms. Quinana and her husband, they are developers, estate developers for quite some time. So I trusted her.
Are you talking about
whatever that she was talking
zoning
about.
and rezoning?
I think it's rezoning or something like yeah.
But you see, Ms. Mamela, the reason you raised the proclamation is because I said to you in February 2016, you owe Ms. Quinana 2.8 million. And
but
you said you don't because there was some proclamation that had to happen. Is that
Yes,
correct?
And I'm still saying it now that you cannot say you owe somebody if the land has not been transferred to you yet.
No, you
see,
pay
if-
and then it's transferred,
if-
Ms. Mamela.
Yes, I know, but remember, you pay and while you're paying, you pay and then the money gets into the account. It does not get transferred to the seller until all the documentation and all the procedure has been put in place.
No, Ms. Memela,
Yeah.
it doesn't seem to make sense to say you don't owe the seller until the property is transferred. Because you need to pay the purchase price before the property is transferred. You see, so when your answer is you did not owe her because the property had not been transferred, that doesn't make sense. You understand?
Yes, it does not make sense for you, but our understanding and arrangement made sense for us. I did not owe her.
Was there an arrangement between the two of you
Yes, that
you would only pay
once the rezoning or
after the property has been transferred?
Yeah, no,
that it
like
would be
after-
transferred first?
No, we'll only pay once that process that I'm talking about has been finalized, which still has not been finalized.
The rezoning.
Yes, Chair.
Well, I think it's a proclamation. I don't think Ms. Mamela, in fairness, knows what the
Yes,
process
thank
was.
you.
You don't know.
Yeah.
Right. But in February 2016, you nonetheless entered into the offer to purchase on the Bedford View house, correct?
Correct.
Which committed you to paying 3.8 million, correct?
Correct.
Right. So in February 2016, you had liabilities for 2.8 million and 3.8 million, which totaled 6.6 million. Is that correct?
No, the liability was only applicable to the Bedford View house.
Right. So
Yes.
because you don't understand the
one-
slip-knot investment
No,
creating
no, no.
any liability for you. Is that correct?
Because when discussed with the seller, it was understood that because it's taking longer, then I can actually move on to another option. So there were no double liability. And Chair, I had already addressed this in Feb when I was here for testimony.
Yeah,
And-
well, if clarification is sought, there will be questions, Ms. Memela.
Okay.
Right, so that's February 2016. Did you speak to Ms. Kwinana then about getting out of it when you'd concluded the Bedford View contract?
Yes, I think we discussed.
Then why did you only cancel Cove Ridge later in May?
Why did I only cancel later in May? Because I think that was the amount that was going to the deposit towards Bedford View that happened in May.
No, you committed yourself to 3.8 million in February of 2016. Your evidence has just been that because of that commitment, you went back to Ms. Kwinana, correct?
No, 3.8, Chair, the bank did not approve the whole 3.8. It just stated the full amount of the house at that time. Then the bank insisted on the deposit. So committing to the full 3.8, I'm not sure I follow your question.
Ms. Memela, when you make an offer to purchase, do you accept that you commit to pay the purchase price?
Yes.
Right.
Through the
That's
bond.
what you did in February of
Yes.
2016,
Yeah,
correct?
through the bond.
And at the same time, you had a liability of 2.8 under the slip-knot agreement, correct?
Yes, in terms of that.
Yes,
agreement.
and you spoke to Ms. Kwinana at the time, you said?
Exactly, yeah.
But then why do you wait till May to cancel the agreement with Ms. Kwinana?
Because I wanted to make sure, I guess, that I will have the deposit that is needed by the bank for Bedford View.
Yes, and where did that money come from
The what?
for the deposit?
Okay, that's the one that Mr. Nzegu bought the
Yes.
land from Mpindweni,
Yes.
1.5, yeah.
Total
went to the
2.5,
deposit.
of which 1.5 was used.
1.5 went to the deposit, yeah.
Yes, you see, that's the timing that's important, Ms. Memela,
Okay.
for what I'm going to put to you today, right? Because it's only upon receipt of the money from Ms. JM Aviation that you then 2 days later go and cancel the agreement with Ms. Kwinana, correct?
Correct.
And what happens in the chronology is the 2.5 million comes into Ms. Mbanjwa's trust account, and then the next day she obtains that client information sheet from you. We saw that that's the 6th of May 2016. And then the next day you go and cancel the agreement with Ms. Kwinana. Is that correct?
That's correct.
Right. Let's just look at that cancellation, if we may. It's in DD 25A at page 397.
At page 39,
397.
DD25A.
Ms. Hofmeyer,
Yes.
let's talk, all of us, about the way forward. We are at 5:05. I would have liked that we try and finish today, but I will have challenges beyond 6. So let's talk a little bit about that. How much more time do you think you need before you?
I have one more issue on the slip-knot investment.
Yes.
Then I'll put certain matters to Ms. Memela, and then I want to deal on one aspect on the GPUs.
Yeah, maybe 15 minutes,
20.
maybe 20. Ms. Mbanjwa, I would have liked us to continue beyond 6 o'clock in order to try and finish. But I'm not going to be able to go beyond 6 o'clock. Should we work on the basis that once Ms. Hofmeyer has finished, we just arrange for you and Ms. Memela to come back for re-examination on another day, or shall we use whatever time is left after Ms. Hofmeyr has finished, and then she will come back. Ms. Memela will come back some other time anyway.
Actually, Chair, there will be no time. Ms. Hofmeyr will go beyond. She will stop your time.
Sorry?
There won't be time. Mrs. Hofmeyr won't finish the first. So that I cannot quarrel. But then the second point which I want to address is the fact that I now have to bring that application for the 2 hours to be extended. And I will give the reasons in the application. I can quickly enumerate them.
No, don't give them now.
Yes, so
Yeah.
I will have, and I can just say what also concerns me is the fact that, and this I strongly note, is the fact that the law is not read properly, and legal questions which are incorrect are put to the witness. So what we are going to do, one of the things we have to do, why we need that, is to just deal with the law, purely with the correct law, and then also deal, of course, with the re-examination. So definitely the 2 hours won't be enough.
Okay, all right. So I think what you are saying is, for today, you accept that you won't do re-examination.
No,
We'll have to look at another time. Okay, I think Ms. Hofmeyr, continue, but try and finish within your
Of
20
course.
minutes.
Thank you, Chair. I really am indebted.
Yeah, okay.
Right, we were at 397 of DD 25A. That's the cancellation letter, is that correct? Ms. Memela, if you'll just turn on your microphone, it's gone off.
Okay, that's correct.
And it reflects the date of the 7th of May 2016, is that correct?
That's correct.
Is that the date on which you agreed with Ms. Kwinana to cancel the Slipknot sale?
I think, Chair, we agreed verbally, then in writing it was put later on.
Right.
Yeah.
And there seems to be something written by Ms. Kwinana at the bottom there, is that correct?
DM, yes, that's Ms. Kwinana is the writing.
And what does it say?
DM Lindy, please action as per the above letter.
And who's that Mlindi referring to?
Her lawyer.
Ms. Mbanjwa. So is this the instruction that was then given to Ms. Mbanjwa in relation to the...
I think so, yes.
Do you think so, or do you know, just so that I can be clear?
Okay, yes, that was the instruction.
Right. And was it given on the 7th of May, as it's indicated at the bottom there?
It's written 7th May, but I'm saying in terms of agreement, Chair, it could have been done verbally, but in writing later on.
I thought that was 2 May.
It's 7.
I think it's 07 with the line,
Yeah,
Chair, because
yeah,
of the
with the
date.
line, yeah.
Is that correct, Ms. Memela?
It looks,
Yeah.
remember, I said I'm not handwriting.
Yes,
expert.
no, that's true.
Yeah,
That's
but it looks
absolutely-
as 07.
Okay. And that's when the notification went to Ms. Mbanjwa, is that correct, from Ms. Kwinana?
Yes, looks
Yes. Now, on the client take-on sheet that was completed the day before, which we looked at previously in Exhibit DD 25C,
Yeah,
page 1135, you'll see right at the bottom, there's another detail indicated there, which is cancelled transfer. Do you see that?
cancelled transfer. Okay, yes,
Yes. And that was completed the day before on the 6th of May. Do
Yeah.
you see that?
yes.
How could Ms. Mbanjwa have known about the cancellation if she hadn't yet received the notification that came the next day?
Oh, of course, they talk. Like I said to Chair, that the cancellation happened through a verbal agreement, but the written one happened later. So they used to communicate.
So it
yeah.
was anticipating getting the written.
Sorry?
It anticipated getting the written confirmation.
Because
Is that
the
right?
cancellation was already discussed verbally. Yeah.
Right. So I just want to put together then, Ms. Memela, what, in summary, I offer to you for an opportunity to comment about the Slipknot investment agreement, right? You see, the agreement was concluded without the involvement of your husband, whereas the law requires him to be involved in order to commit you to a property purchase of this nature. Your evidence is you weren't aware of that at the time. Is that correct?
No, I said I'm not aware, of course, of the law that you are quoting.
Right.
But I said also there are certain lots of things that I've signed without my husband.
Yes.
Yes.
Property purchases?
Yeah, property purchases.
Right. We might want to see those in due course,
I might
governed
look
by
for
the
them.
Alienation of Land Act.
Yeah, I might look for them, yeah.
And then his written consent was a...
My apologies. But can Ms. Hofmeyer, because I am convinced Ms. Hofmeyer does not understand the law on alienation, on FICA, can she please not put these questions to the witness? I will afford her time after I have explained the law. Because that is my difficulty now.
The witness has given an answer, and let's move on.
Yes, but Chair,
You
like
will,
she is being
you will
asked-
clarify whatever you want to clarify
Chair.
in re-examination.
Chair, she cannot respond to incorrect legal questions. It's
She
the
has
judiciary.
responded.
No, but Chair, she cannot
You will
do
clarify it later when you
Chair,
re-examine.
Chair, honestly, Chair, I beg this. A witness cannot be asked an incorrect legal question and
Miss
be asked
Miss
to
Mbanjwa,
respond.
I'm saying,
Please.
if she has given a wrong answer, when you re-examine, you will raise all of that.
Chair,
it will
I
be
cannot-
clarified.
Chair, these proceedings are recorded, they are on television.
Yes.
What is happening here is Ms. Hofmeyer does not understand the FICA Act. And then what she does, she says because of what she sees here, she thinks there has been no compliance with the
Mi-
FICA Act.
Miss-
She is
Miss Mbanjwa,
incorrect. And she
please-
puts that to a witness.
Please sit down.
Thank you,
Please sit
Chair.
down.
We have recorded
Let's
the
try and
prejudice.
finish.
And you committed, Ms. Memela, to paying 2.8 million rand to Slipknot Investments. The month after, you weren't able to raise a bond for 1.4 million with the bank. Is that correct?
I've done that, yeah.
And I understand your evidence to be you thought at some point your mother was going to be able to sell land, which would enable you to purchase the property,
Yes,
correct?
and also, I explained also that, remember the fact that the bank had declined the previous month, because this was going to take longer. Remember, if the bank declines, you can still go and approach them after 6 months.
Yes, but that would have
Yeah.
been a bond from the bank, correct?
bond, yes.
And your agreement didn't make any reference to a bond, correct?
It didn't make reference to cash either.
No, it's a
Did it?
commitment to pay 2.8 million. That means without securing some other source of funds.
It did not say that. We have put that to Ms. Hofmeyer, that the agreement did not say, did not put it to cash, no bond.
So what does that mean?
So what
It could
did it mean?
It could have been either way. For instance, like I could have gone to the bank and could get the bond after 6 months. Because remember now she is focusing on the fact that the bank declined in March. And I'm saying we could have approached the bank after 6 months, where they actually relook again at your profile.
Ms. Hofmeyer?
You didn't have the funds available to you in April of 2015, did you?
No, I didn't have cash.
And you nonetheless entered into an agreement where you didn't complete any client take-on form for Ms. Mbanjwa, the conveyancing attorney at the time. Is that correct?
That's correct.
The only time that was concluded was after the money came in from JM Aviation. Is that correct?
That's correct. And I explained to the chair that sometimes does not have to be done at the same time with the agreement.
Ms. Memela, we will argue in due course
Oh,
that the series of those facts make it very improbable that this was a genuine agreement that was entered into between you and Slipknot Investments in April of 2015. Do you want to respond to that?
remember, Ms. Hofmeyer, chair, that's her vision.
Sorry?
That's her vision, and we'll put our own vision.
Okay.
But I'm offering you an opportunity to respond to it now. That is what I must do, because if I'm going to argue that in due course, I must have your comment on it.
You're saying it's improbable.
That it
That's
is
your
a genuine agreement
That's your opinion.
because of all of those features. Do you accept that?
Okay, repeat that, you said?
I said it's improbable that it was a genuine agreement that you entered into April of
It
2015.
was a genuine agreement.
That's your answer. Thank you. It wasn't something that you devised later when the commission started to investigate this matter so that you could justify the 2.5 million that you'd received from JM Aviation.
Why would I have to justify the commission about the 2.5?
Because otherwise it's a corrupt payment that you received from a supplier to SAA Technical.
The payment for what?
The 2.5 million.
The payment for what?
I beg your pardon?
You said that received the payment from the supplier, and what was the payment for, as you are putting it to me?
You used it, as I understand your evidence, to purchase your Bedford View property and then to spend 826,000 rand after that.
I don't know, Chair, if I understand her question correctly, because he said the payment was payment from the supplier paying me. So I'm asking payment for what? Because she's been making conclusions that it was
She's talking
payment
about
for,
the 2.5 million.
yes, for the land. But I'm asking her
Yes.
now payment for what? Because she's been making conclusions that it was payment for benefits. So I thought like she was making that statement again.
Just
Yes.
repeat your question.
Okay.
Apologies. So it's 2.5 million
Yeah.
that you benefited from that was paid by JM Aviation. Do you accept that?
Yes, to the land of my mother.
Yes. And you asked, why would you need to explain it? And I put it to you that you need to explain it because you were the head of procurement at SAA Technical at the time. And to receive a payment of 2.5 million from a supplier to SAA Technical may involve corruption.
How?
Ms.
Okay,
Memela?
okay, Chair.
How can you
she's
ask
the one
how?
who's asking me. Okay, Chair. Now remember, Ms. Hofmeyer keeps on using, you were the head of procurement, and I thought, okay, you know what, as soon as I get a chance, I need to give clarity to this, as much as I had given clarity in February. The way Ms. Hofmeyer is putting this Nontsasa head of procurement, it's as if I had that kind of power to walk in. Let me make an example now, like where I met Mr. Nzeku in the workshop. To walk in the workshop and say, hey guys, I'm head of procurement. Therefore, everybody gets a tender. You get a tender. You see, like Oprah Winfrey.
Well,
like
no,
when
she
you dish
means
out tenders.
she means if you are head of
No.
procurement, you have certain powers.
No.
You are overseeing procurement.
Chair, that's why I explained also in Feb that there are no powers that are vested onto being HOD procurement. You understand? Because like there are structures that are followed when the tender is ran. So there is no influence coming from the head of procurement that says, that's why I'm saying being a head of procurement does not mean you are dishing out tenders. If that was the case, then it means I would use that power to dish out tenders to everybody, including my family. You understand? Like there is a structure that is followed in each and every SOC, including SAD, that, okay, I even explained to you the role of the CFST, cross-functional sourcing team, that they are the ones with power to evaluate, to adjudicate, to score the suppliers. I don't sit in that evaluation. So to
Are
say...
the people who sit in these structures you talk about people who fall under you?
Sorry?
Do the people who sit in those structures, do those people fall under you?
Okay, the CFST chair consists of people from different departments, being the experts that have to talk about certain component or whatever that you guys are going to go out on a tender. So they sit there, come up with a specification, come up with the tender documentation, and then they do all that independently from me. Then at the later stage, when they have done the shortlisting and scored the highest scoring bidder, they come then to recommend to EXCO through me. I remember, Chair, you even said, okay, like then you are actually used as, and I said, that's what I said. Yes.
But you were the person responsible for deciding to sell the GPUs to JM Aviation at 3.2 million, were you not?
I was not the person who was responsible to decide to sell the GPUs.
No, at 3.2 million was my question.
Even at 3.2 million, I was not a person who, Chair, the determination of the price when it comes to disposal process at SAT, and it's in the SCM policy. I remember I actually explained this to Ms. Hofmeyer and her team during our interview, that's how it works. It does not fall under Nontsasa to determine the price. I even read, Chair, if you still remember, but I'm going to still repeat that during the re-examination. I even read to you a proposal that was made by Jules Air the owner of JM Aviation International, made to the acting CEO of SAT before even the board decided. So when Ms. Hofmeyer puts it like that, you decided that the GPUs must be sold. It sounds like that was the decision to be made by me. The decision to sell the GPUs, firstly, it was made at SAA, and I've been consistent about this because there is evidence that proves this. And
Okay.
yes, and then yeah.
Chair, just so I'm not misunderstood, I'm not putting it to Ms. Memela that she took the decision to sell the GPUs. So, Ms. Memela, we must not be misunderstood. What I put to you is you were the person who decided to sell them at the price of 3.2 million. And I want to explain to you why I put that to you, right?
Yeah.
Because
One
in your
second.
evidence...
1 second, Ms. Mbanjwa.
Thank you, Chair. Chair, there is here before the commission. This is a document that has been furnished to us by the commission. And this document is the affidavit of Julian S. It states expressly who decided the price. What puzzles us is that throughout Ms. Hofmeyer is ignoring this document. It is one of the documents we specifically asked it to be given to us in order to prepare for this re-examination. If I can give her a page reference of that, it is
Ms.
DD26.
Ms. Mbanjwa, even that when you re-examine, you can get it clarified. Ms. Hofmeyer, make a note of all these things that you might want to be clarified, and then you can clarify them during re-examination.
The difficulty, Chair, is that this is not a clarification, if I may be bold to say, is suppression of evidence.
Yes.
It is there. This Julian S. says exactly what is it that said.
Sit
and
down.
it kept being put to this witness that it is her who did it. That is the reason why I just cannot contain myself.
The witness will say what she knows. If she knows that to be true, she will say so. If she knows that to be different, she'll say, no, it's not like that. If she doesn't know, she'll say she doesn't know. When you re-examine, you will revisit the issue.
Your evidence in... Sorry, Ms. Memela.
Yeah. Ms. Hofmeyer, you said I'm the person who decided to sell the GPUs for 3.4, right?
Yes.
Decided.
Yes.
And Chair, I'm explaining this that...
That is the price. Yeah.
That's price determination. And that's her view. And I understand because I don't know if Ms. Hofmeyer has worked for corporate sector before. She's just been practicing, but I'll try and explain as simply as I can, and hoping the public will understand this, because this thing of GPUs keep on coming back to me. Now, there is a difference, Chair, between the disposal process versus the procurement process. The procurement process, you procure, and then through that evaluation team, they go out and make sure that people are competing in terms of price. The disposal, I even wanted to say, I think maybe one day I must make an example to the chair that I will make an example of the auction. I don't know if you've been. I don't think you've been to the auction for the cars.
Please don't make an example.
But yes, but I'm talking
auction.
about disposal. I'm trying to explain disposal, Chair. The disposal, the buyer will be the one who makes the proposal, offer to purchase, to something that is being disposed of,
But Ms.
right?
Ms.
And then
Memela,
I read.
did you decide the price or not? That's the question.
Who decide the price or not?
Did you decide the price or not?
I did not decide the price, Chair.
Who decided the price?
The price definitely was decided by the person whom Jules A. made a proposal to.
And who is that person?
I said it was the acting CEO of SAT at that time, Mr. Asin Malola Piri.
Yes, you
And
see, that's all you needed
Thank you.
to say in response to
Thank
the
you.
question.
So that's why we went to Mr. Perry, and Mr. Perry says he did not approve the price. You know that because you've seen his affidavit, correct?
I've seen the affidavit, and because I know, Chair, that this commission's team have got the evidence that actually proves how much Asin has changed, whatever that he was responsible
Yeah,
for.
no, let's continue, Ms.
yes,
Yeah,
please.
So-
you have answered the question.
Yeah.
Mr. Perry's affidavit sets out that he did not have a discussion with you about the price. Remember, we've got to go back to the 21st of June. 2016? Because it's on the 21st of June 2016 that you have the meeting with Ms. Sakulu and Mr. Ayres. Do you recall that?
Okay, let's go back. Let's go back, Ms. Chair. Remember, I told you about the proposal that
I'm
was
sorry,
made.
Ms. Hoffman, just repeat your question
Yes,
because
I want to go
I want to.
Sure. There's a meeting that Ms. Memela had on the 21st of June 2016 with Ms. Sakulu and Mr. Ayres. At that meeting, they discussed the sale price of the GPUs. Do you accept that, Ms. Memela?
Chair, I was asked by the acting CEO to go ask the people that sent the proposal to him, how did they reach the price that they put in their proposal?
No, I just want to know if you
Ms.
had a
Memela,
meeting.
Just respond to the question. Do
Yes,
you
I had a
remember what
meeting, and I
she's
explained
asking?
also, Chair, in February that I had that meeting, and it was a professional meeting with the JM people after getting that instruction from Asin, and there was
Hang on
Chile.
with the explanation.
Okay.
The long and short is you remember what
I
she's
remember
talking about. Yes.
yes, there's even
An email.
meeting invite, yes.
There's a meeting invite that went to Mr. Makaleng, who said he did not attend the meeting with you, and Mr. Foslu, who said he did not attend the meeting with you. Your evidence in February is that they're lying, they were with you.
He did,
And
they did,
then
yes.
you said you accepted that you couldn't on your own decide on that price.
No way.
You had to speak to Mr. Perry about it, correct?
Chair, the problem now is that Ms. Hofmeyer is only focusing on that meeting.
But she's asking the particular question.
Yes, there is no way that, I would have decided on the pricing because it was not under my department. And since she's referring to Ms. Asin, Mr. Asin Malola Piri's affidavit, the recent one that was only received in September 2020, where he says he did
Hang
not...
on, Ms.
Okay.
Memela. Just repeat your question, Ms. Hoffman.
Your evidence in February was that you accepted you needed to get Mr. Perry's agreement to the price. Do you remember that?
I needed to get his agreement.
Yes, on the price, because you accepted you didn't have the authority to agree with JM Aviation to sell it at 3.5.
No,
you had to get the acting CEO's agreement that it could be sold at that price. Do you
Chair.
remember giving that evidence?
No, Chair. I mean, I think that these are some of the things that I'm supposed to come back and clarify, which is the reason why I applied for a re-examination. Asin gave me an instruction after he received the proposal from Jules Air, right, that, okay, this is what they are proposing for the GPUs, and asked me to arrange a meeting and sit with these people, and then Chila was going to be there as well, being the owner of the GPUs. I invited Leon, who was the senior manager, logistics and inventory at that time, but Leon couldn't make it. The only person that I know that was not going to make it was Leon because he was not in. Then Stan Foslo, because he's reporting to Leon, is the one that came in because he's under sales and materials as well. So
We've traversed that previously. They have said on affidavit they weren't there. You dispute that. That's not
I
what I'm
dispute
interested
that,
in, Ms.
yes.
Memela.
Yeah.
What I'm interested in is your previous testimony, which is that you accepted you had to get Mr. Perry's agreement on the sale price. Do you remember giving that evidence?
when you say agreement, do you mean a written agreement?
No, just he had
Okay.
to agree with you because your evidence was you had a discussion with him. Do you remember
Yes,
that?
I had a discussion because I had to give
Let-
feedback after he instructed me to go and sit with the people and get and understand how did they reach the price.
Yes,
Ms.
and his,
Memela,
Yes.
Ms. Memela, did you need Mr. Perry's agreement on the price, or did you not need it?
Chair, Mr. Perry asked me to sit with the people and ask, because remember they put a certain price there.
Oh, Ms. Memela, did you need Mr. Perry's agreement on the price, or you could do without his agreement on what the price should be?
It was not under my delegation of authority, Chair, to agree on the price.
Do you remember giving evidence previously
Yes.
that you needed Mr. Perry's agreement, or do you not remember?
Chair, I said Mr. Perry even signed the invoice.
No,
Meaning,
no. I'm not talking about the invoice. I'm saying, do you remember giving evidence to the effect that you needed Mr. Perry's agreement? Or you do not remember?
No,
giving
I
such
don't remember,
evidence?
Chair. I think I
Okay.
explained, but like to be specific like that and say, okay, I needed an agreement and stuff, because what I didn't understand is that a person will give you an instruction, and then say, okay, go and ask these people, this is the proposal that they gave me, here is the board resolution. Ask them, how did they reach this amount for their proposal?
Yeah.
And then I go back to him, tell him that they came back to me and say, okay, this
No,
is how
but
they reached the
that's
amount.
fine, Ms. Memela.
Yes,
That's not about
and there's evidence
the
to this,
price. Okay.
And do you
Ms.
remember
Hofmeyer.
giving evidence that you had a discussion with Mr. Piri and you and he agreed on the sale price?
Yes,
You do remember that evidence?
I did give him a feedback. Because
No,
remember, when
your
a person
evidence
gives
was
you...
that you discussed it with him and you and he
Yes, I
agreed on the
did.
price.
Exactly. Remember, when you give back the feedback, is that not, does that not mean you are discussing with him?
No, the important point is that you had a discussion with him and you
Yes,
agreed with
I
him
did.
about the price,
I
correct?
did, correctly.
And that happened somewhere between your meeting on the 21st of July and your communication to JM Aviation that the reviewed price had been approved. Do you recall that?
When you say the communication, you're talking about the letter of award, right?
Correct.
Yes.
Well, it was the letter that confirmed the price.
Yes.
Yes. And that happened on the 22nd of June.
It's not
Do
the
you
letter
recall
that
that?
confirms the price, it's the letter that confirms the approval by the board.
Of the price. Because remember, the approval of the board had already been
proposal
given.
by the board.
But
We'll
Chair,
look at it in a moment. That happened between the 21st and the 22nd. Is
Ms.
that correct?
Bandra, I'll let you know when I want to hear from,
Chair, with
let
all
Ms.
respect,
Hofmeyer
I'm
finish.
exasperated. We have an affidavit of Julian S. It explains exactly how the price was determined.
Ms.
Why is
Bandra,
this client paying
please
better
sit
this
down.
person?
Ms. Hofmeyer.
Thank you. So between the meeting on the
You know, Ms.
21st of
Bandra,
June,
Ms. Bandra, I've had many lawyers coming to the commission when their clients are giving evidence. I've never had somebody who objects so frequently. It hampers progress. Continue, Ms. Hofmeyer.
so you had the meeting on the 21st of June and then the letter confirming the reviewed price was accepted was the 22nd of June. Do you remember that?
The letter was?
22nd of June, the next day.
Okay, is it written that?
Yes. Do you accept that for present purposes, or do you want me to take you to it?
Take me there, because
Yes.
I don't want for you to accuse me
DD
next time.
25A at page 354.
A page?
354.
Yeah,
Do you see it? Is that the letter that we're discussing?
that's the letter, yes.
And what is its date?
Must say the date
Mm-hmm.
is the 22 June 2016.
That's why I said somewhere between your meeting on the 21st of June with Ms. Sakulu and Mr. Ayres and the sending of this letter on the 22nd of June, you had to have had a discussion with Mr. Piri at
course.
which you agreed. Is that
Of
correct?
course, yes.
His affidavit said he didn't have that discussion with you. You've seen that, correct?
Did he send the proof other than saying he was on EXCO?
That's not my question. My question is, have you seen his affidavit where he denies having had that discussion with you?
He denies it, but I have evidence to prove.
You have evidence to prove that he
Yes.
did have the discussion with you.
No, I have
Please tell
evidence to
us.
prove that he's actually the price determiner and he actually is the one who is responsible for that.
That's not the question, Ms. Memela. It's not about who's responsible in terms of the regulations. It's about what happened between the 21st and the 22nd of June.
Okay,
You say you had a discussion and he said you didn't, correct?
I said I had a discussion.
Yes, and his version is you didn't. Have you seen
My
that version?
says I did.
Yes.
Yeah.
He explains why you couldn't have had a discussion. He says on the 21st of June, he was in an EXCO meeting the entire day. And he
21st.
includes the 21st. Sorry, did I say 22nd?
No,
I
it's the
apologize.
21st, yeah.
On the 21st. He says, I was in an EXCO meeting the entire day. He attaches the minutes. They are lengthy and voluminous. Are you saying despite the fact that he was in that EXCO meeting the entire day, you had a discussion with him on the 21st?
I had a discussion with him on the 21st.
Yes.
Yes, I mean, attending a meeting, Ms. Hofmeyer, you do understand whether it takes the whole day or not. There are breaks. And SAT and SAA are just opposite, like the buildings just opposite each other.
So do you have a
So the fact
specific
that
memory
he
of-
was The fact that he was attending that meeting does not mean I did not discuss it with him.
So did you discuss it with him on the 21st, or might you have done it on the 22nd?
I don't remember, but I'm saying I gave him back the feedback from the instruction, because the instruction was, I received this proposal before I went to the board, which was the reason, Chair, he went to the board, as in proposing to the board to get the GPUs sold. And then he said, okay, this is the proposal by Jules A. that was tabled. Please arrange a meeting with these people, and Chaile being the owner, and also whoever is from the sales, which was Leon at that time, but Leon did not make it. So go and ask, how did they reach the amount that they had put in the proposal? So that's exactly what we asked in the meeting. And then I gave feedback to him. So that's why I'm trying to show Ms. Hofmeyer that when she says discussion, the discussion happened there when I was giving him feedback.
But the problem is Mr. Perry denies having had that discussion with you. So I need to offer you an opportunity to explain to the chair why your version rather than his should be accepted, right? Mr. Perry says you didn't have the discussion on the 21st because he was in an EXCO meeting the whole day, right? Mm. I accept that it might have happened on the 22nd because he doesn't say anything about the 22nd. Do you have a clear recollection as to whether you were speaking to him on the 21st or the 22nd?
Yes, remember that was the question that you put to me, that did I give, did I discuss this with him? So for me, I'm not talking about which date and stuff, I just saw that date there. But I'm just explaining, Chair, that the fact that he was attending EXCO does not necessarily mean that we...
You say you are not sure on which day you spoke to him.
I'm not sure which date.
It could be
yes, it
the
could
day
be
of the meeting or the day
exactly.
before.
But what I know is that the feedback was given to him based on the instruction that he gave to me.
But you had to get his agreement, right?
Sorry?
Not just feedback, you had to get his agreement.
Of course, like you give feedback, because remember, he's the person who motivated to the board that these things must be sold.
I want to explain to you why I suggest to you it couldn't have happened on the 22nd of June.
Okay.
Okay, and that's because when you sent that letter of confirming the review price to Ms. Sokulu, you sent it very early in the morning.
Okay.
So early that I would suggest you wouldn't have had a conversation with Mr. Perry before that.
When you say early, what time was it?
5:43 in the morning.
5:43 in the morning. And then you're saying I did not give him instruction between 21 and 22.
No, I'm saying it's unlikely that you would have done it on the morning of the 22nd of June before 5:43 a.m. Do you accept that?
Okay, that's why I explained about the EXCO issue, that the fact that he was attending EXCO doesn't mean...
So you accept you didn't do it on the 22nd?
Yeah.
You would have had to have done it on the 21st, somewhere between the meeting and the end of the day, correct?
That could have happened.
No, but I'm trying to work out the probabilities. You've accepted that you wouldn't have had a conversation with him before 5:43 a.m. in the morning.
It's too early in the morning.
Right.
Yeah.
So it had to happen on the 21st, and the 21st was the day that he was in the EXCO meeting.
Yes.
But your evidence is you spoke to him at some point.
Yes.
Is that correct?
That's correct.
Thank you. Chair, that was to clarify the role that Ms. Memela played in the review price and its approval.
Yes.
We don't have any further questions at this point.
Okay. No, that's fine. We are at 22:06. We'll then have to adjourn, and then another date will be determined when the re-examination can happen. It may be that we might have to do it on an evening, in an evening session, which might start at 4 or 5, going into the evening, because it's difficult to find days that are not already occupied for the rest of, or the balance of the year. Ms. Memela, you want to say something before your attorney says something?
Oh, maybe she can say, in case maybe we want to say the same thing.
Ms. Mandra?
No, Chair, maybe she should speak first because I was going to wrap up.
Oh, okay. She says speak first.
All right. The affidavit of Mr. Asin Malola Piri, I've been asking for it since...
Whose affidavit?
The then acting CEO of SAT, Mr. Aston Malola Piri. I've been asking for it as far back as 2020 January, 2020 February, during that time of my testimony. And nothing was coming forward. And I kept on asking because I had another document, Chair, that was written by Mr. Aston Malola Piri, where he was stating exactly what happened towards the sale of GPUs. And I was only given this, his affidavit, which out of the blue, now it changes. He's denying everything, contradictory to the document that I had sent to the commission and said, okay, this I'm going to use during my re-examination. So since Ms. Hofmeyer is relying on Mr. Assen's affidavit, where he actually denies certain things, my understanding was that I should have been given a Rule 3.2, where, as much as I have asked for it, because remember the rule of the commission is that if somebody says something that implicates you, you should be given a Rule 3.2 so that you are able to actually address those implications by that person and put evidence, so that by the time myself and the attorney come here and set the record straight, we've actually already submitted my own affidavit contradicting exactly what Mr. Aston Malola Piri has written. So you see now, for Ms. Hofmeyer to rely on it now, yet I was not given that 3.2 to respond. So that like when she asks me all these questions, she's able to say, okay, you are saying here, is now I'm only expected to answer according to what Aston had said versus what I had said. And that's giving me difficulty. I'm not sure then, Chair, how are you going to handle that? Am I still going to be given Rule 3.2, where I will be responding to Mr. Aston Malola Piri, where I will prove with evidence that he was the determiner of the price for the GPUs. He was the person that the delegation of authority to dispose of those GPUs fall under his shoulder, and all those kind of, and then I can then make an application to cross-examine him, because I have so much to prove that he lied deliberately. I'm not sure, because knowing Aston is a person that I've worked with since I joined SAT, even before I went to procurement. He's a person with a backbone who stands for the truth. But like after reading that affidavit, the lies that are there and stuff, they left me asking myself, okay, is this the same Aston that I knew? Is this the same person that wrote this, document that I can prove with? I want to cross-examine him, Chair.
I think I know. Hang on.
Yes.
Ms. Hofmeyer, what do you say about that issue of an affidavit?
Well, the first thing I just want to get clear is Ms. Memela says that she provided the commission with some document that she wanted to use in her re-examination related to Ms. Piri. I have no knowledge of that. What document is that?
You can then ask Ms. Chabala, is it Bridget Chabala, the secretary? Yes.
What document was that?
That document was sent in March 2020 after my re-examination.
If I may correct,
Yeah.
Chair, it was sent on the 3rd of April.
Or was it April? Yes.
It was not addressed to Ms. Hofmeyer, it was addressed to the Secretariat,
Yes.
Ms. Rachikana.
Or Rashikana.
I can't say I have any knowledge of it as I stand here.
Yes.
So I would want to see that, certainly. I haven't seen it to my recollection before today, so that's why it came as a surprise to me.
Yeah.
Okay.
Can you just tell me what the document was?
The document, Chair, because remember, this, as I said to you, these GPUs things.
Sorry, Chair, because Chair wants to leave, we have a copy of the document. We will finish with the
No,
document.
yeah.
We had actually made a
Oh,
bundle,
is
Chair,
that
because
so?
we were ready to re-examine.
Okay.
That really has not come to my attention. So I would like to see
Yes.
that. The reason why I'm asking about it now is it is relevant to process, right?
Yes.
It's very important if Ms. Memela has documents that she believes we need to see, we must see them, certainly.
Yeah.
It's why I made the point earlier that what I'm concerned about is a situation where we move to re-examination and they're documents that we should have considered beforehand and we haven't had an opportunity to do so. So we would certainly want to see them. We would also have no difficulty with an affidavit from Ms. Memela setting out her version. That's why she was invited after Mr. Nzeku's evidence to give an affidavit. She requested Mr. Piri's affidavit.
Yeah.
She was given it. There was no affidavit from her forthcoming until today.
No.
So what we would very much appreciate is any documents that Ms. Memela wants to place before the Commission being placed before us, any affidavit that she'd like to put before the Commission setting out her version, she should provide. But the problem is we should get that before her re-examination starts, because there might be matters that we need to traverse. That would be our proposal, Chair.
But is there an affidavit that, Ms. Memela, you say you have been waiting for and you have not received?
Yes, I've been, this is the Asin Malora affidavit, Chair.
You have not received it?
I've only received it on the 17th of September, 2020.
Or you have got
Exactly.
it now?
So that's why I'm saying, since Ms. Hofmeyer is relying on it, and she says he's saying something implicating and whatever. So I'm saying, is it allowed now? Because my understanding is that I should have been given a 3.2 rule, like, so that I'm able to respond to that, and then I can also apply for
Yes.
cross-examination, because I feel the public deserves to know the truth.
Yes.
Because Nontsasa sits here, she keeps on getting asked all these questions.
No,
and
no,
then,
no, that's
yes, so
all right.
I really need that.
Yeah, that can be arranged, Ms. Mbanjwa and Ms. Hofmeyer will talk about that, that will be arranged and discussed.
Yeah.
Should not be a problem.
Certainly.
Okay, all right. So you have raised what you wanted to raise, and the way forward about that is sorted.
You haven't answered me, Chair. The cross-examination, am I going to be given a chance to apply?
You are paying that lawyer, remember? She must work for these fees. She must give you advice. Ms. Mbanjwa, you wanted to say something
Yes,
before we adjourn?
Actually, Chair, I'm so happy that you are saying I am paid, therefore I must give legal advice, because then Chair will accept that. I object all the time, not because I'm impertinent, but because I'm paid. There's a late advocate who said when he was asked by a judge, he said, "Judge, I'm paid to be courageous, so I'm paid to object." Thank you, Chair, for being patient with us.
Yes.
What we are going to say, Chair, I was going to suggest that instead of us requesting the 3-2, I can see the time constraints, and we really appreciate the fact that Chair is prepared to meet us on an evening. We really appreciate that, and we are grateful for that. So what we are going to do, we are going to bring an application. That is a formal application under oath, where we are going to ask to cross-examine this person, this AC. And then the other thing which we are going to ask for, Chair, because that is what is going to take time, because without maybe casting aspersions on the investigating team and Ms. Hofmeyer, but we have looked at the manner in which the evidence has been presented. We feel that it is presented in a negative light. So consequently, what we are going to do, there are certain affidavits which are already within the Commission, which we are going to ask permission to read into the record, because it is very important that they get read into the record. And then when the Chair makes his whole conclusion, then he could be having all that. And then lastly, Chair, there is the issue of this legal. We just believe that the evidence leader, as we have said, doesn't understand some of the legal provisions. So we will just then have to do an explanation of what each of those legal provisions mean. And then we'll submit it. Thank you, Chair.
Yes.
Chair, we speaking from the legal team's perspective, anything that Ms. Memela wishes to place before us, we would welcome. Her version, whatever she wants to say about Mr. Piri, applications to cross-examine, if she wants to do a document in which she sets out where she thinks we've got the law wrong, we invite that. We would want to consider it. Thank you.
Can I be...
Sorry?
Can I add just one thing?
What is that?
It's just something that I read out of these many books that I read. I don't know if you're aware of the 48 rules of law. And I came across, like, because you see, when these things keep on being put to you, you end up asking yourself, something is at play here. I'm trying to understand. And as I was reading that book, I saw Rule 26. When you get the chance, when you're at home sitting and sipping tea, read that, I promise you. And then it talks about, I'm finished. It talks about...
Please stop there.
I want, because I'm trying to understand, like, why people want to appear clean and they're pushing everything to nonsense.
Please stop there. We are going to adjourn. Another date will be determined. In the meantime, certain things might happen, including the filing of an application,
yes,
and the exchange of documents, but another date will be communicated as soon as possible. Thank you to everybody. We are going to adjourn. The commission will sit tomorrow to hear the evidence of Ms. Frolic, Member of Parliament. We adjourn.
Thank you, Chair.
No? Okay.